Item number 50. Islam, the learned. What impugn order is this?
Lordship, initially, by considering the court's order, he was transferred to a particular post. Subsequently, that was cancelled and he was again transferred to another place. Now,
Modified.
he challenged the second order.
Second.
Okay. There was a stay.
Yes.
Oh, that matter.
Lordship, that general matter.
Because in only two transfer matters I've till now given a stay. I remember that matter. So you sought for 1 week's time. That
Yes,
matter, no?
Lordship. In the meter, second order has been cancelled.
Okay. Mr. R. Aslam, the learned counsel, appearing on behalf of the petitioner, and Mr. P. Naik appearing on behalf of the BTC. The learned counsel for the petitioner submits that in the meantime, pursuant to the order passed by this court, the order impugned in the petition has already been recalled, and he has been again posted back to the place. Some ICDS.
Zolo ICDS. JALAH.
He has already been posted back to ICDS. And then I remember the date. The impugn order dated 10th March 2023 was cancelled, and thereby the order dated 1/3/2023 has been brought into force. Has already by order dated so and so, he has been now posted at ICDS Jaro.
Lordship 28/3/2023.
By an order dated 28/3/2023. Taking into account the same, the petitioner submits that he does not want to press the petition. Accordingly, the instant petition stands closed on the basis thereof.
Shall I provide a copy?
Not necessary. 28/3.
Yes.
Daily list item number 1.
Yes, Mr. Saikia.
By of this petition, the petitioner is claiming
The volume was increased because of you. So better speak out loud. Otherwise, you will have to again hear the dangerous sound. Yes, what are you challenging out here?
is claiming the pensionary benefits and the gratuity, my lord.
Why you have not been given?
My lord, his service was not regularized.
Oh.
That is why, my lord.
Your service was not regularized. How do you get the pension then?
My lord, Apex Court has, my lord, recently in the decision of the Apex Court held that,
This is MRSR judgment,
my lord, that
the
is-
30 years,
yes, my lord,
2 paragraph.
my lord.
Then
Uh,
that having taken the services for 30 years, you
Yes,
cannot deprive them from pension. But what do you say about yesterday's judgment of by the same bench, wherein it says that there is a contractual appointment with these people were there, and under such circumstances, they are not entitled to pension.
But my lord, Rule 31 of the Assam Services Pension Rule, my lord.
So unless you are not regularized, how do you get pension? Can you get a pension?
Yes, ma'am.
Tell me.
Rule 31. That is the provision of Rule 31 at page 6 of my petition.
Yes. What does it say?
My lord.
Rule 31 has 3 conditions.
Yes.
First, he has to be a government service.
My lord.
Second, it has to be permanent and substantive.
Yes.
And number 3, he has to be paid out of the coffers of the government.
The
Now,
proviso,
where do you fall in?
my lord, in the proviso.
That has been regularized by the governor
Yes,
by
that-
giving that the
but
declaration.
A declaration is required to be given by the people.
Has it been given?
No.
Then how do I help you?
That it is pending, my lord, in the other series of petitions, my lord,
Huh?
regarding payment of pension. The people issue notice in the, my lord, aspect. But the other issue, my lord, regarding payment of gratuity is under the gratuity. That will be directed to pay.
Why haven't you asked for the regularization also? The prayer for regularization.
Yesterday, I have come to a judgment, my lord, when I was sitting in court. Actually, my lord, there is a provision for regularization of, so recently, Supreme Court has said
regularization of your service.
Yes.
And then applying Justice M.R. Shah's judgment of this 30 years.
Yes.
Then on the basis thereof, seeking a declaration. No, I don't think a declaration will be necessary for that regularization and then
Once
for
regularized,
getting the
declaration is
benefit.
considered.
I think something would be made out. But without asking for that, would it be proper? How can I give it to you?
But
But unless and until you are not confirmed, you don't have a right of pension.
confirmation is not required. Confirmation is not required. I have given a memorandum at page 19 of my petition.
Hmm.
Only the 20 years service is required, not confirmed.
Well, this one, 6th of April.
But for this also, he needs to be first regularized. Then it can, the question of confirmation arises as per the OA. He's covered by the Upendra's judgment. He's a casual worker. He's been appointed on a casual basis. And at present, he's
And
covered
then
by the Upendra.
he's not on that, not getting minimum of scale of pay. He's not on that.
He has not even applied for a regularization. He's never given us any representation as such, as far as the regularization is concerned. Confirmation is a far-fetched thing at this point of time.
You have two options. Either submit a representation there, and thereafter you come. Thereafter you come. Huh? No, thereafter you come. After regular representation, unless it is not given, then you can come over. But prior to that, how do you?
In the series of Upendra's case, my lord, that was for regularization only, my lord.
No.
In
This
that
is
case
not,
also as a
this
part-
is a regularization being asked, taking into account that you have rendered so many years of service, and as such to regularize you only for the purpose of pensionary benefits. Nothing more than that,
that part of the,
because otherwise there is no regularization.
Yes.
The regularization will only have post facto.
Yes.
And prior to that, and as such, that regularization will help you in getting this one. Although no family pension, that's another problem. Hmm?
by granting liberty to the petitioner to file a representation. And the other part for the deputy.
I am not granting you the liberty. I am only saying that you have liberty to file whatever you feel like. You withdraw this petition, and with the liberty, the withdrawal of the petition shall not preclude you from applying here, and if so agree to approach again. That is what I can give.
Gratuity, I am that.
Huh?
Gratuity, I am that.
Gratuity.
I have two payers.
You are entitled to the gratuity.
Yes, ma'am.
How?
The similarly situated persons fulfill final page 23,
Wait.
23 and 22, my lord. 21. And 23. They are
Page
also-
21.
Yes, my lord. They are also master than casual workers, my lord. They have been granted the gratuity. by the-
This gratuity is under that thing, the terminal benefit. 151.
under the Gratuity Act.
No. I think terminal benefit. You have the pension code.
I bought the
Oh, without the pension code, you are appearing.
I bought the
It is as if you're appearing in
pension code
civil
as
bench
well as the
1 without the CPC.
I bought the pension code as well as the payment of Gratuity Act. Junior sir,
Payment of gratuity act is different. I think they are giving you under 151.
151.
152,
151.
152. Sorry. They're giving it to you under this. But if you take this, you're finished. This is only given to those people who is otherwise, if you are only on this, then forget about the pension. I don't think you should pray for that if you have any idea. But otherwise, you take instruction. If he's happy with the gratuity, they will be happy to oblige you by paying under 152.
Forgo the pension.
Eh?
Forgo the pension, take the gratuity and leave.
Are you going to take that?
I will take instruction.
You want that?
I will take my instruction.
Better off. Because otherwise you are in trouble. Okay, heard Mr. I stated as well as Mr.
P. Handek, my lord, on behalf of K.
For the
PNR.
petitioner and Mr. P. Handing appearing on behalf of the which department?
PNRD, my lord.
PNR
On behalf of
department.
K.
And Mr.
I am for respondent number 4, my lord.
He appears on behalf of the Director of Pension. Let the matter be listed when.
Before you. Anything.
Okay, we'll have it on 10.
Fine.
At the request of the learned counsel for the petition, and matter will be listed on 10th of April.
Item number 2.
May it please your lordship.
Yes, madam.
The registered notary have not released the arrears salary with effect from 11/12/2014 to 21/11/2018. Actually, lordship, the petitioner is removed on 11/12/2014. So kindly see page number.
No. You were removed on 11/12.
Removed from
Why are you
11/12.
asking for this amount?
11/12, Annexure 7, page number 23.
Page number 20,
6.
Huh?
26.
16,
26. 26.
26. So you have been removed from
Yes,
11/12/2014.
Yes, lordship. Then the petitioner kindly see annex page number 30. Annexure 10.
Correct? Yes. What is it?
Yes, lordship.
Petitioner
The
challenged this order.
is honorable High Court is set aside and was the two show cause notice. One is that 11/12/2014 and another is 23/6/2014. So kindly see 33 and the last paragraph number 6. On the pertinent questions and law raised by the learned counsel for the petitioner is that no presenting officers was appointed when the inquiry was conducted on the charges
Okay.
leveled against the petitioner. It is
Yes.
the law.
Lordship, notice may issue lordship in this petition lordship, the joining letter or any document for rejoin after a court order lordship, because it is missing here in this writ petition. Therefore, instruction is necessary.
Okay. Miss
Yes, Chakravarti.
S. Chakravarti, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears for respond number 1, 2, and 3.
All lord.
Issue notice making it returnable by 15th of May 2023. As the respondents are duly represented by Mr. J.K. Goswami, extra copies of the writ petition be served upon him within 3 days. It is a case of the petitioner that the petitioner was dismissed from service by an order dated 23/6/2015. By an order dated 11/12/2014, which the said order dated 11/12/2014 was set aside by was affirmed in appeal by an order dated 23/6/2015. Both the orders dated 11/12/2014 as well as 23/6/2015 were challenged before this court in WPC number 5993/2015. This court, by the judgment on order dated 1/11/2018, had set aside the orders dated 11/12/2014 and 23/6/2015. It has been submitted that the said order has not been challenged by the respondent authorities thereafter. Under such circumstances, the petitioner claims arrears salary
With effect from
for the period from 11/12/2015 at 11/12/2014
2014 to
to
21/11/2018.
21/11/2018. The learned counsel appearing on behalf of the respondent shall apprise this court as to why the petitioner is not entitled to the said amount. On the next thing.
Item number 3.
May I please, Your Lord?
Yes, Mr. Bhattacharya.
Lordship, in this case, the petitioner who had retired from service, Your Lordship, as Deputy Registrar, Your Lordship, of Tezpur University, has retired on 31/12/2021, Your Lordship. And
Grant one notional increment
Lordship.
for the service rendered by the petitioner from Toronto. I think. Okay.
increment is normally fixed, Your Lordship, on next date of his retirement for last 1 year of service he has rendered.
Mr. Bhattacharya, I think better off we issue notice here.
Lordship,
But Mr. S. Bhattacharya, the learned counsel appearing on behalf of the petitioner. Mr. A. Gogo appears on behalf of the
all the respondent,
respondent
all the
numbers.
respondent, all the respondent, Lordship.
You are Tezpur University.
Lordship, all the
Very well. Appears on behalf of the respondent number 1, 2, and 3. So issue notice making it returnable on. When can we get your instructions?
Okay, after due, Lordship. Commencing from 25th, Lordship.
We'll have it on 8th of May.
Lordship.
Issue notice making it returnable on 8th of May 2023. The case of the petitioner herein is that the petitioner claims to be entitled to the grant of one notional increment for the service rendered by the petitioner with effect from 1/1/2021. And for a further direction that the respondent authority should refix the petitioner's pension as well as other retirement benefits by taking into account the one notional increment due to the petitioner for the period above mentioned. In that regard, the petitioner has referred to the orders passed by the Delhi High Court
Lord.
dated 23/1/2020, as well as the coordinate bench of this court dated 26/7/2022 in WPC number 4447/2021. The learned counsel appearing on behalf of the respondent authority shall apprise the court on the next date as to why the petitioner would not be entitled to the claims as made in the writ petition. Liberty is given to the petitioner to mention the matter for upgrading. Get your instructions.
Item 4.
Yes, Mr. Sharma.
May I please, Your Lord?
Why are you depriving him? Something you have
We are
done.
not the one who are depriving him, my lord. My lord may,
My lord, petitioner retired on 30/6/2009, my lord.
Hmm.
He has not received the, as per the revision of, as per the Assam Services Revision of Pay Rules 2010, my lord. And the GPF has been calculated from the year 1994, my lord. As he has joined the services on 18/3/1976,
And you retired?
retired on 30/6/2009. He has
Why
rendered
are you
service
before
for
this court now?
claiming for area salary and retirement benefit.
Area salary is 3 years. Why you are coming now? You have a paragraph out here detailing the reasons for your delay and latches.
Gratuity has not also not been received by the petitioner fully, my lord.
Gratuity is okay. That is where this court can take it. But what about the area salary?
Lord,
Yes, Mr. Chairman.
My lord may just, he has to make the AEGCL the party. He has not made them the party.
AEGCL.
Yes, my lord. My lord, what has happened after before AACB was there, after the bifurcation, this trust of AACB employees fund and is with AEGCL. We write them the order and they are the disbursement authority. So why it's not been dispersed, it's not, will be the perfect position.
AEGCL.
Yes, my lord. My lord may find it at page 23. There's a type copy.
Oh, Assam Electricity Grid Corporation Limited.
Yes, my lord.
They are the authority.
Yes, sir. They are the authority for the disbursement, my lord. We had written the order to them.
Yes, what is your name?
A. Gayan.
A.
Gayan.
Dan. Appears on behalf of the petitioner, Mr. S.P. Sharma. S.P. Sharma
Yes, ma'am.
appears on behalf of the respondent number 1, 2, 3, and 4.
One and the
Oh, you. Okay, Ms. M.D. Bora appears for the respondent number 1. Mr. S.B. Sharma appears for the respondent number 2, 3, 4. Mr. Sharma, Mr. S.B. Sharma, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent, submits that the instant writ petition and that no effective writ can be issued in the instant writ petition without the Assam Electricity Grid Corporation Limited be made, without the Assam Electricity Grid Corporation Limited being a party to the instant writ. In as much as after the
bifurcation of AACB into the three parts, APDCL, AEGCL.
then what?
So then this employees trust is with AEGCL.
In as much as after the bifurcation of the Assam State Electricity Board into 3 parties, the pension fund.
No, my lord, it is AACB Employees Pension Fund Investment Trust. That is at page 26, my lord will find.
The
Page 26, Annexure 5.
where are you?
2-member and chief executive, AACB Employee Pension Fund Investment Trust, AEGCL, Bijuli Bhavan, Annexure 5.
Authority for payment of pension to Kala.
Yes, ma'am.
Where?
Issued by
Pension
AEGCL,
fund, where is it?
my lord. At top, my lord, 2-member and chief executive, comma, AACB
okay. In as much as the AACB Employees Pension Fund Investment Trust is controlled by the Assam Electricity Grid Corporation Limited.
Limited, ma'am.
Taking into account the said submission, this court for the ends of justice include the Assam Electricity Grid Corporation Limited having its office, registered office at Bijuli Bhavan, first floor, Paltan Bazaar, Guwahati 781001 as the party to the instant proceedings, as respondent number 5 to the instant proceedings. Issue notice making it returnable on 15th of May 2023. Ms. M.D. Bora accepts notice on behalf of the respondent number 1, Mr. S.B. Sharma appears on accept notice for respondent number 2. Issue notice making it as Ms. M.D. Bora as well as Mr. S.B. Sharma accepts notice on behalf of the respondent number 1, 2, 3, and 4. Extra copies of the writ petition be served upon them by 31st of March 2023. As regards the respondent number 5, issue notice steps be taken by way of registered as well as usual.
My lord, may the word control be replaced with purview, my lord.
Huh?
The control of may be permitted with purview, my lord. Purview of the my lord.
5
Please, Your Lord. This is regarding staying of the impugned transfers order of this applicant. Two transfer orders were there, 23/11/2022, followed by 12/12/2022. And the applicant, he is actually a central government employee working in the Departmental post in the position of
Department of?
postal service. He's working as a senior superintendent. He's currently holding the post of a senior superintendent of postal officer in Dorong division as school. My lord,
You approached before the CAT?
yes, my lord. We had approached CAT for the first time, and then CAT had stayed that order. The transfer order in the first instance dated 08/03/2021 with valid reasons. Then what happened, my lord? Again, even after having that particular order, the respondent authorities went ahead and they had rejected my representations. My representation is in page number 46, next and kindly peruse to page number 46. Here I have stated with all the
No, let us come to page 67.
my lord.
That's the CAT's order. Paragraph 7.
Yes, my lord. In view of the above, respondent number 2, that is the Chief Postmaster General, Department of Post, Assam Circle, Panbazar, Guwahati, is hereby directed to consider the representation of the applicant dated 24/11/2022 and communicate his decision by way of a reasoned and speaking order within a period of 6 weeks from the date of receipt of the copy of this order. In the meantime, impugned transfer order dated 23/11/2022, that was annexed A1, in respect of the applicant is stayed till 2 weeks from the date of communication of the order of the respondent number 2.
Then
Yes, my lord. Then after this order was passed, he had made another representation.
why? Already there was a representation. Why you are giving more representations?
No, my lord, after 24/11/2022, just a minute, my lord.
You gave another representation with better particulars. Yes, then what happened?
My lord, after this particular order was passed, in the meantime, he had approached the Honorable High Court.
Why? Who?
The applicant, the petitioner.
Yes.
He had
Then
approached the Honorable High Court and by filing a writ petition, this is the second time.
challenging the order of CAT.
No, not my lord. He wanted to approach the Honorable High Court when he had got the stay. Then, since that particular stay was insufficient, since he had some valid reasons, so he had filed another particular case in the CAT, which he had later withdrawn it. The reason behind that was that the case, the next case, subsequent case, which was filed by the applicant in CAT, during the pendency of that case was to be heard in the first week of January. So since the holidays had begun and since the urgency of his transfer order, so he had approached the Honorable High Court by withdrawing that particular petition. And by approaching the Honorable High Court by way of writ petition 8455 of 2022, he got interim stay, and then later on, the Honorable High Court on 1/2/2023, that is the order dated 1/2/23, that is Annexure B, page number 74.
78.
74. And the operative part is 78.
Let us read page 78. Read it.
Yeah. The operative part, that is the last paragraph. The fact of the matter is that on 28/2/2023, the petitioner's daughter's academic sessions will not be over. If that be so, no practical purpose would be served by directing him to join in the new place of posting on 28/2/2023. Therefore, taking note of the overall facts and circumstances of the case, as well as the stand taken by the learned counsel for both the sides, this writ petition and the connected IA is being disposed of by providing that if within 7 days from today the petitioner submits an unconditional undertaking in writing before the respondent number 2, stating that he would join in his new place of posting as per the transfer order dated 23/11/2022 on or before 31/3/2023, then in that event the petitioner shall be permitted to continue in his present place of posting till 31/3/2023. It is, however, made clear that if for any reason whatsoever the petitioner fails to give such an unconditional written undertaking or fails to comply with the undertaking given by him, then in that event, it would be open for the authorities to take appropriate action against the petitioner in accordance with law without serving any further notice upon him. My lord, subsequent to the passing of this order, he had given a unconditional undertaking to the respondent authority to the competent respondent authority on 6/2/2023, which is not being annexed here, since he had given that particular undertaking, but he had not taken a receipt copy. So he has given a copy which was not received. That is why we have not annexed it. But he had given an undertaking. Now coming to the fact that while this whole matter was taken up, he was going through mental depression. He was having some depression. But he had not disclosed that particular fact on the earlier previous petition, which was filed before the Honorable High Court. It was on the ground of his academic ground of his girl. He has a 9-year-old daughter who was studying in Standard 4. And while this whole case was going on, she was appearing in her final exams. So based on her
my lord, the earlier judge who passed that order,
my lord,
he is too lenient, not this court.
Yes, my lord. My lord, there was an administrative exigency that is to be taken into account. But my lord, there are guidelines. As per
The order was clear. You are to give an undertaking that you are going to leave on 31/3.
My lord.
Matter ends.
But on medical ground, my lord.
No, what?
Just I'm
medical
now
ground.
under treatment, my lord. Page
Let
number
us see
82,
what
my
is
lord.
your medical certificate?
Page number 82.
What you are having?
I'm having mental depression, my lord. So that is why I had also been I visited the Lokopriya Gopinath Kotla Mental Center in Bajpur, my lord. That is in page number 82. Annexure. That is annexure W, my lord. Page number 82, which is along with my representation, which I had again applied it to the before the respondent authority for extension of my tenure for a few months. So I am not in that position that I am not going to leave my post and I'm not going to join the new.
Mr. Counsel, when was the order passed by this court earlier?
1/2/2020.
And this person at the time when he filed the petition at that point of time was not in proper mental health?
Yes, yes, my lord. He was undergoing treatment, but he had not disclosed it at that time, my lord.
So at that point of time, he could not.
My lord.
Because on 1/2/2023, the order was passed. And this document at page 82 is dated 30/1/2023.
Yes,
that means,
my lord, the thing is.
and what has happened thereafter?
No,
he was to be reviewed after 1 month. What happened thereafter?
I mean, he has already sent a representation to the.
No. What has happened thereafter? This was done on 31/2023. Then he again went out there on 28/2/2023.
Yes, fine.
What has happened? Is it any certificate that you are not in a position to move?
My lord, I will crave leave of the honorable court produce it if it is there.
No, not necessary. We dismiss it on that ground itself.
My lord, on the ground of medical, which is there in.
Earlier, this court had taken the best thing and gave a very clear thing that you have to give an undertaking. That undertaking is not here. Now you have come up with another thing, that you are under a mental depression for this has happened. And there is no certificate, anything, medical documents to show that you are not in a position to be transferred or go anywhere. You have tried all your best. You have gone into many other aspects, neither in those representations which have been submitted, even in the appeal, which was submitted later on. Also, there is no mention to that effect. Now, once everything was closed in CAT, so you come before this court. This court gives you a reprieve for another 2 months, 1 or 2 months, or almost 2 months. Then also now you are coming before just at the end of this you are coming.
My lord, on
what do you want to do? Dismiss, withdraw, which one? Nothing doing.
My lord, on medical ground,
I told you, no? The earlier judge was very lenient. I'm not. Which one do you want? Withdraw, dismiss, which one?
My lord, I will pay for withdrawing the petition
There.
and will file it with the liberty to file it if it is with the new record, if it is there, with the medical record.
Same cause.
What records?
If he's undergoing the treatment and there's a certificate which he was unable to produce it this time, if he can produce it, then we can file it on at least on that
Then
particular.
why did you spoil the 15 minutes of time of this court?
My lord, apology, my lord.
Then
My lord, just with the liberty to file, like if it is there.
what? The moment I give you the liberty, I know the. You see, I have come from that side to this side
Yes.
not long ago, so I understand that aspect. If it was long ago, I may not have understood that.
Right.
So I understand the moment that liberty is given, you come up next time. Yes, we have given the liberty, and as such, I'm here again for by bringing on record those documents. Isn't that your case, which should be on the next occasion?
My lord,
And because of that liberty, your case gets more strengthened.
my lord, on the basis of it, at least those guidelines which are there,
What guidelines?
That- since he was a employee in the.
You have given an undertaking before on the basis of the court's order, you have given an undertaking before it. And I said that you are going to be posted there. At that point of time, you very well knew that you were not in a proper medical or mental condition, as you have stated, because on 31/2023, this has happened. And a person would not go to the mental hospital on just one day before the matter is taken up. The reason is that he must have experienced something prior to that. So therefore, at the time of filing, this was within his knowledge that this has happened. That was never your case at that point of time. Now, how can you make a case to that effect and you want the liberty for strengthening your case? And Madam Sharma opposes it to the nail. Yes.
My lord, I don't want to waste any more time of it.
Hmm?
Don't want to waste any more time of this.
No,
Mrs. Kavanaugh.
don't spoil any more time. There are other councils
Yes, yes.
waiting up.
My lord,
I only give you only one thing. You can submit a representation and the authorities may consider. Nothing more than.
my lord,
I have,
one
but that has nothing to do
Yes.
to get any order that this court has said anything not to transfer you or withholding the order of the transfer dated 23/12/11.
man,
It would not touch on that. This is subject to withdrawal.
yes, yes.
Heard, Mr.
WR made.
W.R. Mehdi, the learned counsel appearing on behalf of the petitioner. Miss B. Sharma appears on behalf of all the respondents.
1 to 4.
1 to 4. Full stop. The learned counsel appearing on behalf of the petitioner submits that taking into account the facts involved, he would not like to press the petition. Consequently, he, however, submits that withdrawal of the instant writ petition should not preclude the petitioner to submit a representation to the authorities concerned to consider his case in view of his health condition. Taking into account the said submission, the instant writ petition stands dismissed on withdrawal. It is made clear that the withdrawal of the instant writ petition shall not preclude the petitioner to take such action as deemed fit in accordance with.
Obliged.
6,
Yes, Mr. Padgi.
Non-payment of family pension.
Huh?
Non-payment of family pension. The husband of the
Mr. Dhar, why you are doing this? 197A. What is this?
interest for delayed payment.
Huh?
Interest on delayed payment.
Directing to finalize the arrear and current monthly family pension. When did your husband get the pension?
No, my lord.
Master
During the
worker,
course of service, my lord, he died.
Confirmed?
My lord, this is to verified, my lord, whether the 20 years of service.
It is not required, my lord. 140. Rule 140, minimum 1 year of service required, my lord. While the government employee died, during the course of service.
Died.
Died, my lord.
Then he had 1 year after being confirmed. Oh, therefore, earlier pension doesn't arise. Very well.
Earlier pension doesn't arise.
No, no. Pension to the husband does not arise. So she's entitled to the family pension,
pension.
taking into account that he was a regular employee. Regular employee.
Regular,
After 1 year, having done 1 year
my lord.
of service minimum.
I will get the instruction. Then.
When? How many years you have not got? When did your husband die?
Died, my lord, in the year died on, my lord, 2011.
What?
13/5/2011,
And you have been running.
my lord. The respondent has pleaded that, my lord, the husband of the petitioner never completed the 20 years of service.
Hmm?
My lord, verbally, my lord, informed the petitioner that, my lord, he has not received family pension as because the husband of the petitioner never completed the 20 years of service after deduction of 6 years initial. My lord,
Because of 6 years.
6 years death.
Sanjita Roy.
Sanjita. My lord, death is not, but because, my lord, died during the course of service, my lord. He is not
Otherwise, you had 20 years.
20 years.
You had.
That-
His date of retirement is, this is the order you are challenging.
No, my lord, no order has been passed, my lord.
No, what is this? Annexure 2?
Annexure is the, my lord, is the regulation order, my lord. Page 18. Regulation order has been individual regulation order 14/10/2005. And thereafter he died on, my lord, 13/5/2011. Ought to have been retired, my lord, 31/12/2029.
No representation.
No, ma'am. I have verbally approached before the, my lord, authority, my lord, but he has not taken any step. My lord.
Why have you verbally approached? And to whom?
My lord, station superintendent, my lord. Respondent number 6, my lord.
Where? Where have you mentioned?
My lord, paragraph number 4, my lord. That the petitioner begs that after death of her husband, the petitioner asked before the various authorities and verbally approached for interment death benefit, including monthly family pension from the death following the death of her husband, but it seems that it has not processed for the apportion entitled to petitioner has submitted required document and that as and when asked to submit.
But Mr. Padgi, does it look nice for not approaching the authorities by way of filing a submitting a representation? Did you submit the death certificate? Then
My lord,
tell me one thing, Mr. Padgi. You are a well-seasoned lawyer out here. You say that she has approached since 2011. With what? For what?
for family pension, my lord.
How? How? Because you have to show that she is dead. Have you given the death certificate?
Even death certificate. Also.
When did you get the death certificate? You got the death certificate in 2020. Then?
20.
Then? That is why I asked you. Where is your representation? The paragraph number 4 is false.
Subsequently, after my lord, after obtaining the death certificate.
Do you have advised your client to move them, the authority first?
My lord.
Why they have not approached the authority and you have made a false statement to the effect? Why should this court at all exercise their jurisdiction? Why they have not approached?
After 2020, my lord, I have approached after obtaining
When?
the death certificate.
Where's your certificate? Where's your representation? Then-
I have not annexed, my lord.
Then where you mentioned that in 2020 you have approached.
Even para 4 is back, nothing, no details.
Mr. Padgiri, when a
I have
lawyer
instructed-
appears, we trust them on the face of it. Don't put yourself in my black book. Where's that? You have it now. Should you put his name? Don't put your name out there in that black book. We trust whatever you say. But why have you made a false statement? This is a false statement. And now you're saying that after 2020 you have, why haven't you approached? Is it easier for filing a writ petition and getting an order? Why you are saying that because of 6 years have been removed because of Sanjita Roy? You don't know that.
But the respondent has a duty, my lord, to,
Duty for what?
my lord,
They may have passed an order for not, the person having not appeared, that even after regularization, a person is not appearing for which they may have initiated departmental proceedings against him for his absence and terminated him. That may happen. So why haven't you approached the authorities?
as per my instruction, approach before the authority, my lord.
Where is your instruction to the
representation
effect?
also.
You should have, then shouldn't you have asked them to submit a representation before them, the authority concerned, that this is the facts out here, this has happened.
But no copy.
But why
photocopy-
should this court entertain this writ petition out here on the basis thereof
but
without submitting a representation?
representation submitted, my lord.
Where?
No copy, my lord, has been.
Where is your submission
No,
that
my
the
lord.
representation has been
No,
submitted? Give me a copy, give
No,
me a one statement in your petition where they have submitted a representation. Earlier you were saying that he had made a verbal representation. Now you are saying that he has submitted representation. Isn't that completely different from the earlier one? Didn't you say just now that it is a verbal representation?
My lord, my lord.
Then
It's categorical, my lord, verbally approached
Then,
in para 4. Categorical.
and now you're saying that after 2020 you have given. Demanded justice from whom? You don't know. This I will issue notice that imposing cost upon the lawyer at 50,000 rupees to be paid from your pocket.
No, no, no.
This is the on the basis of which you go and file appeal before the.
My lord, then I withdraw, my lord, with regard to.
No, why will you withdraw? Why will you withdraw this matter out here at the cost of the petitioner? You should have advised the petitioner to that effect. You are a seasoned lawyer. You should advise the petitioner, submit a representation and then come if they don't do anything. How these authorities will come to know that this person is dead?
Respondent authority has the duty, my lord.
नाम तो लिख ही लो, black book. Yes. Heard Mr. K. R. Patni, the legal counsel appearing on behalf of the petitioner. And Mr. R. Thought appears on behalf of the respondent number.
My lord. Respondent number 1 and 3, my lord. 1, 3, 5, 6, 1, 3, 5, 6, my lord.
1, 3, 5, and 6. MD Bora, pension. Appears for respondent number 2. Mr. B. Chakraborty appears for respondent number 4. And
Accountant General, my lord, 5, 4, my lord.
that's it.
And Treasury,
None appears for the finance department on cause. The learned counsel appears on behalf of the petitioner submits that there is a finance standing counsel appointed for the finance department of this court. Issue notice making it returnable. How long to get your instructions? Because this needs to be done as fast as possible.
My lord, 2 weeks.
We'll have it on 26th of April. Issue notice making it returnable on 26th of April 2023. As the respondent number 1 to 6 are duly represented by their respective counsels, extra copies of the petition be served upon them by 31st of March 2023. As regards the respondent number 7, the petitioner is given the liberty to take steps by serving a copy upon the Standing Council of the Finance Department.
Finance.
The case of the petitioner herein is that the petitioner husband, one Dulal Pukar, was appointed as the master roll worker and he joined on 26/11/1990. Subsequent thereto, on 22/7/2005, the government 22/7/2005 subsequent thereto, on 14/10/2005, the husband of the petitioner, the services of the husband of the petitioner was regularized as grade 4 with effect from 22/7/2005. And in the same order of regularization, it was mentioned that the husband of the petitioner would retire on 31/12/2029. Unfortunately, the husband of the petitioner expired on 13/5/2011, as would appear from Annexure 3 to the petition. It is, however, relevant to take note of that the perusal of the said death certificate shows that the said death certificate was issued only on 11/5/2020. The petitioner herein, being the wife of late Dulal Pukar, being entitled to the family pension, have approached this court upon an allegation that the respondent authorities have not granted her the family pension. On the returnable date, the learned counsel appearing on behalf of the respondent shall apprise this court as to whether the petitioner would be entitled to the family pension, and if so, what steps have been taken in that regard.
Right.
So you're not there. You'll have copy of it. Itu naam tu titik itu lihat biar kita.
Number 8 for admission.
Yes, Mr.
May I please your lordship? Here is the case, lordship. Petitioner, original petition from Mahmuda Khatu, The first wife of the deceased employee, pension has been sanctioned in the name of second wife. So that's why this case was filed. And due to the pendency of the writ petition, Mahmuda expired.
Whom expired?
With writ petitioner expired.
Then what is your right?
Right, yes, lordships. Children, I filed an application for interlocutory application for improvement of the respondent, improvement of the children of disease writ petition.
For what?
Because-
Claiming what?
Yes. Pension, since it's a pension includes as a property. My mother was entitled till her death, that may kindly be refunded to the children. That is the
File
case.
civil suit for that.
Nothing on that legal point of view.
File civil suit for that. You have entitled for that. This is
Civil
absolutely
suit.
between both of you.
Civil suit, liberty may
Now,
be
how can I ask that? If she was alive, the thing would have been
Yes, yes,
different.
certainly.
And
lordship.
now with the full
Yes.
bench judgment, she gets it. Mr. Biswas,
If you was
you are
allowed,
appearing for the
certainly
second
was
wife.
entitled.
I am the legally married wife. She's after the death of the husband, suddenly she appeared. Sir. I was
Oh, that only always happens.
I
Well,
have
when
the-
I was
All the
getting pension, now
experience
they
I
stop.
get, I get that only happens all the time. The first wife brings up from somewhere that I am the one. But be that as it may, the law is after the first wife, the second wife
Second
gets
wife
it. Now
gets it,
she has gets it. There's no quarrel with that after
Yeah.
the death of the petition.
Yes.
But as regards the claim, that is only
Claim.
subject to a civil suit. That can't be
The liberty
decided.
may be granted, lordship.
There's an interlocutory application that has been allowed. So, that is why none is appearing in this matter. That has been allowed.
I think not
The
allowed.
requirement is the right to sue and so and so. Okay. So many questions being raised. No, I has not been allowed.
Lordship has not yet been allowed.
We have filed an objection also to that.
On what ground?
It is not maintainable
Why?
because they have got no Lucas standing now. My mother is no longer there. During the lifetime of the husband, she never came up.
No, but whether should be
And in the service
whether the
book, my
prayer
name is there, my lord.
All
whether
documents,
the prayer in the
children's
petition.
documents, birth certificate.
Wait, Mr. Bolhuya, let me argue for you. Wait for 5 minutes. Yeah. Whether in the petition, there is no prayer that she should get the amount, it should not be issued. Clarity and pointing the But Mr. Bolhuya, you don't have to pay for that amount.
Actually, that time she was alive. That's
So
why.
no, therefore your
Yes.
cause of action doesn't survive.
Yes, technically, lordship, during that time, it was that pension may be granted in February. Okay, she was alive. Subsequently,
So
expired.
that your cause of action doesn't survive with this.
30
But anyway, this should not stop you from
approaching the
approach.
lot.
So I think we dismiss the petition on the ground of abatement and close the petition of this IA on the ground that if you have any claim, you can pursue in the civil court. That is the only way out. Because without, on behalf of a dead person, we can't go ahead.
That's happened.
And they can't be the representative, legal representative for this case.
Yeah.
Isn't it?
Yes.
Heard Mr. F. Bolhuya, counsel appearing on behalf of the petitioner. Mr. S.R. Bulwa appears for
Respond number 2, Lordship. Director of Pen.
Respondent number, director of pension. You are appearing for? What is your name? Going to appear for respondent number 5. Elementary NJ Khatoni appears for respondent number 1, 3. Who appears for the treasury? Mr. A. Solia appears on behalf of the treasury. And Mr. S.C. Biswas appears on
respondent
behalf
7.
of the respondent number 7. The instant writ petition was filed by one
Mahmuda Khatun.
Mahamuda
Mahmuda Khatun.
Mahamuda Khatun, claiming to be the first wife of late Abdul Salam.
Exact.
The case of the petitioner hearing is that the respondent authority have been illegally giving the family pension to the respondent number 7, which ought to have been given to the petition. The praise in the petition, in the writ petition, are for setting aside and quashing the sanction letter of family pension issued in the name of the respondent number 7, semicolon, for a mandamus directing and commanding the respondents not to give effect to the sanction letter of family pension in the name of the respondent number 7, as well as also for a direction that the respondent authorities should disburse, public release the family pension in favor of the petition. In the meantime, during the pendency of the writ petition, the petitioner
Died on 10/10/14.
Mahamuda Khatun
7
expired on
7/4/18.
2018.
7/4/2018. Where's the death certificate? No death certificate.
State.
Sir?
That certificate not annexed statement is the paragraph 3 of IL, page 5.
7/4/2018. This aspect of the matter could be gathered from the fact that the petitioner's sons have filed an interlocutory application being IAC number 608/2019, wherein it has been mentioned that their mother, the applicants of the said interlocutory application have stated that their mother expired on 7/4/2018. In a recent judgment of the full bench in the case of MUSTT Junufa Bibi versus MUSTT Padma Begum, reported in 2022 SCC Online GAU 2000, it has been categorically held that the first entitlement to the family pension would be to the eldest of the widow, and thereafter to the and upon the demise of the eldest of the widow, the further widow, the second or such further widow, would be entitled to, and thereafter only the minor sons, minor children would be entitled. In view of the judgment of the full bench, even assuming the respondent number 7 is the second one. Then also, on the admitted death of the petitioner, the respondent number 7 would be entitled to the family pension. Accordingly, the question of substituting the applicants instead of the petitioner in the instant case does not arise. Applicants of so and so, I conde, to the accompanying writ petition, to the present writ petition does not arise, as they are not entitled to the reliefs which were sought for in the writ petition. Consequently, the instant writ petition therefore abates. It is also, however, it is this court deems also to observe that at this stage, this court also finds it relevant to take note of a submission of Mr. F.U. Barbuya as regards that to the effect that the pension being a property, the entitlement of the said pension to her mother, to their mother, to the mother of the applicants in IA number so and so, stood devolved upon the death of their mother to them. And as such, a direction be given to the respondent number 7 for the purpose of payment of the said amount which she had received as family pension during the lifetime of the mother of the applicants. Mr. S.C. Biswas, the learned counsel appearing on behalf of the respondent number 7, states that the respondent number 7 is the only legally wedded wife of late Abdul Salam. And as such, the question of the mother of the applicants getting any amount does not arise. Further, he submitted that this is an interstate dispute between two private individuals. And as such, this court ought not to exercise any jurisdiction under Article 226 of the Constitution. This court duly agrees to the submission made by Mr. S.C. Biswas to the effect that the dispute as to whether the petitioner, the applicants to the IA, applicants in IA number so and so, would be entitled to the said amount would require an adjudication of the facts as to whether the mother of the applicant was at least the wife of late Abdul Salam, which can only be decided by a forum wherein the facts could be adjudicated. Considering the above, this court therefore disposes of both the, while disposing of the writ petition as abated, disposes of the interlocutory application by holding that the applicants are not entitled to be substituted in the to the writ petition. However, they may seek such remedies as available under law. For recovery of the amounts from the respondent number 7, if deemed fit.
Diploma.
Obliged.
Duita order, huh? Accordingly, both the writ petition as well as transfer and dispense.
Nine.
Yes.
My lord, this matter pertaining to my lord illegal and irregular teacher, my lord, Tamaze. So my lord, as per my telephone instruction, maybe she is accommodated as tutor, my lord. So I need some time so
You
that I
are?
can.
What had happened, my lord, in respect of the irregular teacher is concerned, out of the 752 numbers of the teachers, my lord, the 35 teachers who earlier approached before this honorable board, they had not terminated from their services till date. And subsequently, their services were regularized and salary was given up to 2007. From the August 2007, their salary was stopped, madam. Then they approached before this honorable court. Out of 35, 24 persons approached before this honorable court.
No,
And
no,
these
Mr. Counsel, when did you last talk to your
But
2017?
yes, thereafter also.
When? This
But,
year?
in 2000, in the midst of the
Pandemic?
2021, he retired. He already retired from service in 2018.
Then how, if he retired in 2018, how will you appoint him as tutor?
No,
No, no. What he's saying is on a different context. He's saying that you come within the ambit of the illegal irregular appointment, which were regularized in 2020, by which the area salary have been waived. But if he has retired in 2018, how is it possible for you to apply that?
Maybe they are similar name, my lord. They are confusion. They already retired, my lord. So present status of
Service of the petitioner regular in 1992. 25th August 1992.
No, Mr. It doesn't look nice that a matter of 2017 you have not filed your affidavit.
Yes.
And we are still in the realm of a telephonic instructions. We're into telephonic instructions in a matter of 2023, not even in
my
2020.
lord.
But for 2017, 6 years back, this is it. We impose a cost for not filing the affidavit. Or we should allow the writ petition. Which one do you want? Either. of them. I give you an option.
I pray sometime so that my lord I can approach
10,000? Upon whom? Salary, somebody's salary has to go. Then it looks nice. Director of elementary? Elementary. Cost of the year paid by the year from the recovery of. Heard Mr.
R.
Islam, the learned counsel appearing on behalf of the petitioner, Mr. B. Taluka, appears on behalf of the Elementary Education Department. It appears on record. No, full stop. The instant writ petition was filed challenging the order dated 27/3/2014 issued by the Director of Elementary Education, Assam, as well as also to release the regular as well as the area salaries of the petitioner with effect from August 2007. Where is that order of 27/4?
My lord, page 56. 56, 27/3/2014.
What is your name?
My lord, my name is Lokti Prabha Burwa.
Is your name there
Yes, yes.
Huh?
Yes.
in this order? Are you affected? Do you come within the 752 numbers of teachers
No, my lord, what has happened,
appointed again non-existent post?
this order has been passed pursuant to the Honorable High Court's order dated 24/9/2008, only at page 48,
Hmm.
wherein this petitioner was the petitioner. Present petitioner was the petitioner.
Okay.
in that
Now
petition.
tell me one thing. You are affected by this order of 27/3/2014.
Yes,
In this order, you have been held to be appointed against non-existent post.
Yes.
Is it?
it is not at all correct, my lord. That's why this challenge has been made before the Honorable Court.
Why you are saying not at all correct?
Because, my lord, earlier occasion, the service of the petitioner was not terminated. And
First, you show me that you were appointed. Where is your appointment letter?
the appointment letter is at page 20.
Date
23,
22.
3, my lord.
Yes.
Then subsequently her service was regularized.
Against the retired vacancy of Sutiram Gogoi.
Yes,
Now, thereafter,
the service has been regularized. Page 35.
let us see one thing. In pursuant to the director of IMA, that is the IMA, it is hereby regularized with effect from 2
It was submitted to regular person under the civil petition condemn number.
when the government memo dated 3/10/1989,
It said it would come after that.
That has not been annexed there, my lord.
and
Then regularized, my lord. Then their services was stopped.
this regularization happened in 92.
19,
92.
1990,
92, page 35,
page 35, my lord.
92.
92, 25 August 1990.
Thereafter comes 1993, where you have been given salary.
Yes,
You continue to receive till 2007.
August 2007. Then it stopped. Then the writ petition has been filed before this honorable court.
Then you file a writ petition.
Yes, page 48. Along with
What
the
is the order? Let
23
us
other
see.
teachers. My name is at serial
This is
number
a
20.
division bench order.
Yes.
Why?
Because the earlier litigation was continued in the division bench. The
Okay.
contempt case,
Your name is there.
their name is as paid. My name is 22 serial number. Page 40.
Let us see how to- You were not terminated. You were not terminated.
No, I am including in the 35. Then this input order.
Then you file contempt.
Contempt. Yes. And thereafter
What
this
happened to
input
the
order has been
contempt?
passed.
Issue notice, then they start.
Yes. But
And
in the meanwhile, my lord, after passing this,
another petition is filed.
my lord, after passing this input order, my lord, out of the 24 persons in the earlier writ petition, the 18 have approached before this honorable court, and these honorable court categorically set aside the input order. This is as at page 59. And this petitioner sought for the similar relief as already given by the court. Page 15. By taking into consideration all the aspects, the input order has been set. But unfortunately, petitioner was not the petitioner in that.
Okay, so you want a similar order?
Yes.
Yes, Mr. Talukdar, I'm coming in 5 minutes. Why is court didn't talk? So they can't be brought within that. Is that the petitioner was appointed on 19/12/1989 by the Deputy Inspector of Schools, Dhemaji, as assistant teacher in Dhemaji Nagar LP School. Mr. Islam, you were a part of this contempt petition
Yes, madam.
at page 25?
Page
25.
Yes. Page 29 is the list of the petitioners. And my name reflected at page 30, page serial 30. Page 30.
Name of which are the contempt petitioner? Of which one?
Yes, page 29.
Thereupon, there were certain directions being passed for the purpose of granting the salary to the petitioner by this court. As those directions were not complied with, a civil original contempt, the original petition bracket contempt number 105/1988
Yes.
was filed. How can that be filed by in 88 and you can be a party when in 89 you were appointed?
Well,
In 88, how can a contempt petition be filed when in
no,
89?
what had happened, this petition was filed initially before the regular appointment, my lord. Initially, the petitioner along with other person temporarily appointed against the retired vacancy for temporary basis. Then the government has issued a notification by which fixing the qualification percentage of marks as well as the basic training course. They approached before this honorable court that the untrained teacher should not be restrained to participate in this selection process. Then this honorable court has directed that the untrained teacher should not be debarred from participating in the process. And pursuant to that order, this contempt petition has been initiated. And during the pendency of the contempt petition, the present petitioner along with others, they have been.
Contempt to decide. Subsequent thereto, contempt to decide, petition file, there were some salaries not paid and all inside. Was appointed in the year 1989 as an assistant. Subsequent thereto, while the petitioner was serving, a show cause notice was issued to the petitioner along with other similarly situated persons by the inspector of schools Dhemaji, alleging that their appointments were irregular and against non-sanctioned posts under the Dhemaji subdivision. The petitioner, upon receipt of the show cause notice, had submitted a reply. However, subsequently on 12/5/1992, the Director of Elementary Education issued a letter whereby instructions were issued to the Deputy Inspector of Schools Dhemaji to terminate the irregular teachers by issuing termination notice and the payment of salaries to those irregular teachers for working period till termination was being considered in the light of the orders of this court. But the termination notice of the person under civil rule number 212/1997 and civil contempt, original
87,
contempt
87.
petition, original petition contempt number 105/1988, including the present petitioner, was kept pending until further instruction, for which the petitioner was not terminated and she continued to render her service. Thereafter, the Deputy Director Elementary Education, Assam, issued a letter to the Deputy Inspector of Schools Dhemaji dated 7/7/1992 as regards the regularization of services of 35 teachers, including the present petitioner. On the strength of the judgment and order of this court dated 18/6/1990, passed in contempt case number 105/1988. Pursuant thereto, by the communication bearing number 10708-14 dated 25/8/1992. The services of the petitioner was regularized from 1st of July 1992 on the strength of the judgment of this court dated 18/6/2009. 18/6? 18/6/1990. And the
Yes.
specific order of the government by memo number EPZ-857 of the 89 of the 2 dated 3/10/1989. It was further mentioned in the said order that the petitioner may be allowed to enjoy the monthly salary with effect from July 1992, and the aerial liabilities will be made as soon as sanction is received from the Director of Elementary Education. It further can be seen from the writ petition that there are various correspondences exchanged by the there are various interdepartmental correspondences exchanged as regards the payment of the area salary to the petitioner and similarly situated persons. Surprisingly, on 11th of December 2007, the Director Elementary Education had issued a communication to the Commissioner and Secretary to the Government of Assam, wherein reference was made to the teachers, the 35 teachers, which includes the petitioner. In that regard, it was mentioned that one A. Doloi, the Deputy Inspector of Schools, Dhemaji, had submitted a report stating that 35 group of teachers were kept pending from termination by the termination order dated 12/5/1992. The said out of the said 35 group of teachers, 5 of such teachers were called for personal hearing on 22/9/2007, for which necessary report has been submitted to the government. And the government was requested to instruct the office on the matter for taking necessary action from the end. At that point of time, the petitioner's salary, which she was receiving from July 1992, stopped. It further transpires from another communication dated 23/6/2008, issued by the District Elementary Education Officer to the district, what is this, DEO?
district elementary education officer.
Elementary
Education officer.
education officer to the, no, it is issued to whom?
Issued to the district elementary. Actually, what had happened, Mal, he is the DI of school, but subsequently he in the charge of DEO.
It further reveals that there is a communication dated 23/6/2008 issued by the DEO and in charge DI of schools Dhemaji to the district elementary education officer Dhemaji, wherein it has been mentioned that the salary of the 35 teachers, including that of the petitioner, were stopped. Subsequent thereto, there was a writ petition which was filed, that is WPC number 5085/2008. By 24 out of the 35 teachers. The petitioner herein was one of the petitioners to the said writ petition. This court disposed of the said writ petition by then order dated 24/9/2010. By passing certain directions which are mentioned herein under, which are extracted herein below. At page 51 of Pabo, page 51 of 52. And in the face, comma, Kaprarambo. Because although the said directions were issued as far back as on 24/9/2010, but the respondent authorities did not take any steps for which a contempt proceedings was initiated, being contempt C number 121/2013. It appears from the record that this court had issued notice. It further appears that thereupon the office of thereupon the Director of Elementary Education Assam passed an order on 27/3/2014 holding inter alia that the 24 writ petitioners, including the petitioners who filed WPC number 5085/2008, claim was not maintainable as the appointments were against non-existent posts. For which the question of release of the salary did not arise. The learned counsel appearing on behalf of the petitioner has further drawn the attention of a judgment passed by a coordinate bench dated 17/2/2017 in WPC number 3286/2014, wherein out of the 24 petitioners, 19 petitioners filed the said writ petition. The petitioner, however, the petitioner herein, however, was left out. The coordinate bench of this court, as stated, by the judgment and order dated 17/2/2017, allowed the said writ petition by setting aside the order dated 27/3/2014 and with a further direction to the respondents to release the area salary of the petitioners therein from August 2007 within a period of 4 months from the date of receipt of the certified copy. The learned counsel for the petitioner submits that in the meantime, the petitioner have already retired. However, the petitioner is still entitled to the area salary from 2007 onwards and claims parity with the order, judgment and order dated 17/2/2017, the benefit of which have been already granted to those 19 petitioners who have filed the said writ petition. That is WPC number 3286/2014. It appears on record text that on 10/7/2017, this court had issued notice and therein also, in the said order, it was also categorically mandated, mentioned about the order dated 17/2/2017 passed in WPC number 3286/2014, whereby the order, speaking order dated 27/3/2014 was quashed. Almost 6 years have passed by, but the respondents have not cared to file any affidavit. Upon perusal of the judgment, this court, upon hearing the learned counsels for the parties, and upon perusals of the materials on record, including the judgment passed by the coordinate bench on 17/2/2017, whereby the order dated 27/3/2014 was quashed. This court is of the opinion that this court finds no reason as to why the same parity should not be given to the petitioner, taking into account that the speaking order dated 27/3/2014 stands already quashed in respect to the 19 petitioners out of the 24 petitioners who initially filed WPC number 5085/2010. 2008. Considering the above, this court therefore, this court further deems it appropriate to quote the relevant portion of the judgment of the coordinate bench in the case of the judgment and order dated 17/2/2017 by the coordinate bench, Paragraph 12 of 17, 18. Huh? Page 62, page 64. Considering the above, this code therefore allows the writ petition thereby quashing the order dated 27/3/2014 insofar as the petitioner herein is concerned. And further, directing the respondents, more particularly the elementary education department, to release the area salary of the petitioner from August 2007 within a period of 4 months from the date of receipt of a certified copy of this order by the Director of Elementary Education, Assam. With the above, the instant petition stands alone.
Much obliged.
Number 10.
Yes.
Here in this petition, my lord, petitioner is claiming area subsistence allowance from 15/10/2004 to 31/12/2007.
How much did you get? 50?
Now he is receiving at the rate of 50%.
You should have got 75
Yes.
after 3 months.
Yes, ma'am.
That is it. The entire case is that.
Yes, entire case is not that, my lord.
But then
He is
what
also
else?
claiming his area subsistence allowance, my lord, from 15/10/2004.
That is it.
Yes, ma'am. That is it.
So you say that 3 months was there for which you need to be given 50
Yes.
and you are still getting 75. You are still getting 50.
Yes.
Now, when did you meet or have a word with your client? This is a matter of 2017. And what is your stand?
Yes, madam. In fact, he has filed another writ petition claiming for reinstatement, madam.
Very
In that writ petition, reinstatement in the service, madam. In that petition, we have filed our affidavits, categorically stating that his initial appointment was against non-sanctioned post, madam, without any selection. That stand was taken, madam. And that writ petition was dismissed, madam. Not on merit, but on dismissed for non-prosecution. Non-prosecution, madam. Dismissed for default. This is the WPC number, my lord, 1472/2017.
No, understood. But the question is, Mr. Counsel, when did you meet your client last or have a word with? Is he still under suspension?
I have
Why
to
was
take
he put
instruction.
under suspension? Because if this court passes an order to give you the benefit of giving 75%, would he not continue to get it till now?
I will take instruction from my client.
And what about the earlier writ petition?
Earlier writ petition was, my lord, disposed of, my lord, directing them.
You
to
have the
release.
order?
Order has been annexed.
Where?
These are the writ petition of 2007, my lord.
2007.
I'm talking about a writ petition filed in the year 2017, praying for reinstatement in the service.
Is it a case of suspension?
Yes, my lord.
And he has been suspended from 2017?
2004, my lord.
Oh, my lord.
Going on?
Yes, my lord.
Why? Why haven't you terminated?
That is for that, my lord. In fact, in the other case, we have filed our affidavit. So may the matter may be take along with this dispose of writ petition so that we can find out the reason, my lord. Because there is an order of
Because you need to take that also, because
Yes,
why
yes.
have you put a person under suspension?
Yes, sir.
Suspension cannot be punitive.
and his suspension because of in connection with his
apart from
criminal
that,
case.
I don't understand. you may put under suspension for a short time, but you are to only decide as regards his legality of his appointment or not.
Yes, yes, my lord. Yes, my lord.
But are you not spending the public money out here by
That-
keeping him under suspension in respect to a person who is illegally appointed?
Yes, ma'am.
Let us assume that he is illegally appointed then.
Yes. That was the observation made by this honorable court on 24/7/2018, my lord. In fact, I have seen the order in the earlier petition. That was the
Definitely.
observation made by the coordinate bench of this honorable court.
Then why is he still under suspension? All this 75% should be taken out from that official. I think that is a better way because public money has been thrown out.
Yes, yes,
You
my
should
lord.
have taken the decision immediately.
Yes, my lord.
If a person is there till 2004 let us assume till 2018. In 2018, he was still suspended.
Yes, yes.
So for 14 years, you keep him under suspension
And
in
pay the-
respect to a allegation that he has been appointed against a non-existent bond, meaning thereby his appointment is illegal.
illegal.
Then how can you keep it for 14 years? How are you paying that 50% also?
Yes.
He is entitled to 1,000 or 2,000 rupees also. 2,000 means 50% is 1,000 rupees. 1,000 means 12,000 rupees in a year.
Yes.
And you have just, for example, in this case, from 14, almost 14 years into 12, which comes to the how much? Yes, your name?
Yes, by then.
As Upadhyay, learned counsel appears on behalf of the petitioner, Mr. N.J. Khatani appears on behalf of the respondent, Elementary Education Department. The learned counsel appearing on behalf of the petitioner submits that he has no instruction as regards the present status of the employment of the petitioner. Mr. N.J. Khatani, the learned counsel appearing on behalf of the Elementary Education Department submits that there is disposed of.
Dispose of.
There's another matter connected, which is another matter which is connected to the instant proceeding, which has, however, been another matter, another petition which have been disposed of, but has a bearing on the dispute involved in the instant petition. That is WPC number
1472/2017.
1472/2017, which was disposed of on
12/12/2020.
12/12/2020.
22.
22. Taking into account the same, let the instant petition be listed on 10th of May 2023. In the meantime, the registry shall tag along the said petition, that is WPC number so and so, on the next day.
I'm highly available.
Okay.
11.
Yes.
Regarding area salary lottery.
What? Area salary.
Kindly will look at Annex 3, page 12.
What is this area salary business? From when?
From the date of effect lottery.
Where is the area salary?
He was given the selection grade scale lottery with effect from 2013.
Convey the sanction of the governor to an amount of so and so being the area salary. Sanction is done.
Annex 3, page 12.
Page 12.
It is a similarly situated person, the amount has been granted.
With reference to Accountant General 99, with reference to I am directed to say that the lecturers of so and so noted below are in the pre-revised scale of so and so.
There was Dr. Umakanto Devu Sharma. He was granted salary.
Mr. Counsel, tell me which is the period of area salary you are asking for?
Lordship, for the period, Lordship, 1/1/1996 to 31/12/2002.
96 to 31.
12,002.
You filed in the year 2017. When have they given anything to that effect? Stated anything that they have accepted that amount?
Lordship, kindly will look at Annexure 5. This is a letter from AZ Lordship. Annexure 5, page 16.
By the senior accountant.
To the
That is in
secretary.
2001.
Lordship.
How much is the amount?
It was not amount, it was intended to clarify the position. Lordship.
Allowing the increment benefit to be allowed to be of the. Then
Then there was another notification, Lordship.
Huh?
Then Annexure 6, Lordship.
What is this 5A?
5, Lordship.
Page 17.
But he was given the charge of principal of that college.
What principal? This is allowed to. Okay, then
Held the current charge of principal.
allowing the selection grade.
Not-
Then
Was already given the selection grade.
I have not been given the 3 consecutive annual increments on my basic pay of rupees so and so with effect from so and so till date after my retirement from service on 2002. I have written several letters to so and so. This was given on when? What is the date of this letter? No date. Very well. Prayer
Date
for
was the
fine
20
settlement from Dinesh Sharma to the education 2009. I hereby earnestly request your kindness to sanction me the same selection grade. Now, so and so, Umakanta Sharma. Who is Umakanta Sharma?
He was the person along with the petitioner given the selection grade itself. By the
Okay,
state
1,44,000.
Similarly,
Directed to convey the sanction to Umakanta Sharma. Then,
my recent instruction is that I have communicated with the petitioner.
but why even after 2009 you have approached in the year 2017? Tell me.
But my lord, recent instruction is that so far communication has come.
No, you can't. You retired in 2002. Then why did it take you 21 years as of now for moving the matter after 15 years? Tell me. I can't help you. Yes, what are you? Is you entitled to?
My recent instruction is that
That
some
instruction, Lordship, I have to collect.
college for calculation of the salary.
No, not this calculation business out there. If you're asking for area salary, whatever may be,
Not
that has to be there then. Why haven't you? Why have you moved after 15 years? Tell
since
me.
2009, Lordship, there is communication from the authority.
Petitioner have approached in 2009. Then why now? Tell me.
On 2017, it was fine.
Then how do you take note of the judgment of the division bench in Harendranath? What is it? Harendranath Sharma or what?
Then I'll leave it to Lordship.
Yes. 3 years, na? Area salary. Then can't help you. Yes. Don't go by what I have said to him.
Lordship,
You come by
otherwise, Lordship, I
yourself.
do not have any instruction, Lordship, though notice was issued in 2017, Lordship, but we do not have any instruction, Lordship.
When did he retire? 2002. At the age of 58. 58. Because
At that time, it was 50.
58. And filed it after 15 years. Huh?
The instruction of the
That is clear. You don't need instructions for that.
2009, Lordship, yes, like for
15 years, which means that he should be aged about 73 then. Today is 79.
my humble concern is as the matter has already been taken up by the
What?
the notices have already been issued and taken appeared.
what?
Releasing the
No,
salary.
where will he get documents now? That is why the 3 years has been put, unless there is something process. You show me some process to the effect,
Then I'll leave it to Lord.
can't help you. Where's the judgment? When do not take a- Hmm?
2013 PLT 109.
Let you. If it was a pension, I could have helped you. Not area, because I'm bound by the division bench judgment. Heard, Mr. Arpukon, the learned counsel appearing on behalf of the petitioner. Mr. Departmental appears on behalf of the Higher Education Department. AG? No AG. The claim of the instant of the petitioner hearing is for area salary.
And extra 3 lot.
For the period. From 1/1/1996 to 31/12/1998.
31/12/2000.
Huh?
31/12/2000.
31, but all these documents in 96 to 98 has been shown. Where is it? 2002. Huh? From one, no. Claim for area salary, which stood accumulated on account of annual increment, or on account of what?
Granted selection rate still not. That area salary. Just
On
given
account
effect of
of granting him the selection grade scale of, no, that is not there, no.
an extra 3 lot.
On area salary
Lot.
for the period from 1/1/96 to 31/12/1998. Admittedly, the petitioner had retired in the year 2002. Anything else?
Lot. 31/8/2000.
Huh?
31 of August 2000.
You have retired. Admittedly, the petitioner have retired on 31st of August 2002. From a perusal of the writ petition, the grievance of the petitioner is that the similarly situated person have already received the said salary, said area salary, as far back as in the year 2001 itself.
2009 perhaps.
No, as far back as on 2009 itself.
An extra 8.
There is no explanation in the writ petition as to why the petitioner has approached this court after 15 years from his date of his retirement for the arrears salary. For the period from 1/1/1996 to 31/12/1998. There is also no explanation as to what the petitioner did
That paragraph I have just mentioned.
after his retirement, except submitting two representations in the year 2009. It is no longer res intriga that by submitting representation, you cannot enlarge by submitting representation. The period no longer res intriga by submitting representation, one after another, the delay as well as latches can be explained. This court further takes note of the judgment of the division bench of this court in the case of Harendran Chandra Nath and other versus the state of Tripura and others, reported in 2013 to GLT 1094. When in paragraph number 10, it was categorically observed that there is no right to recover the arrears beyond 3 years from the date of the filing of the original writ petition. The date of filing of the writ petition. Taking into account that the claim of the petitioner was for the period from 1/1/1996 to 31/12/1998, and the writ petition was filed in the year 2017. This court is not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution in the facts of the instant case on account of delay as well as latches. It is, however, observed that this writ petition has been dismissed on the technical ground, and the same shall not preclude the petitioner, shall not preclude the respondent authorities to consider such representation if the petitioner serves upon them. That is as far as I can, nothing more than that. Well,
This matter will become infectious, madam.
Huh?
Become infectious, madam.
Mr. M. Saroni, the learned counsel appearing on behalf of the petitioner, it admits that the writ petition has become infructuous I've also heard Mr. P. Chaudhary appearing for
Finance and taxation.
the finance also
Finance and taxation separate. Lordship.
appears on behalf of the Finance and Taxation Department, the government of Assam. Taking into account the said submission, the instant matter stands closed as being infructuous.
13,
Yes,
13, Lordship, the petitioner is retired from the post of principal, Lordship.
retired.
Superintendent from the post of principal, Lordship. And during his service period, Lordship, one DP was conducted by the college, Lordship, regarding an overall misappropriation of funds there, Lordship. Some recovery is there, Lordship. Now, present status, Lordship, I have to obtain instruction, and he has transferred from that particular college to another college also. That college he has retired, Lordship. And I have also asked my
So
friend,
what is it challenging?
Lordship.
The challenge was regarding
Washing the report numbering 13. What is that report?
what has happened, my lord, during the tenure of as a principal in Vilasipara College, there was some untoward incident regarding some college activity. Thereafter, my lord, there was a report which was obtained from the director of financial.
Anyways, you will get your instructions.
Yes.
Heard Mr.
K. Mohammed.
K. Mohammed, the learned counsel appearing on behalf, and Mr. K. Koi appears for the Higher Education Department. Both the councils are directed to obtain instruction as regards the present status
Lordship.
of the petitioner. It's the matter on 28th of April 2000.
Lordship.
Obliged.
14,
May I please?
Yes,
In this case, your lordship, I have the instruction to withdraw this case. Because succession certificate, succession case is pending. Because of that, and it is in final stage, your lordship.
NN Upadhyay.
And
Heard Mr. NN Upadhyay, the learned counsel appearing on behalf of the petitioner.
Z Bora, Lordship.
P. Bora appears for the Agriculture Department.
P for Gary for AG.
And so appearing on behalf of the authority here, the accountant general. No finance. The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the petition.
not in perspective.
Huh?
I'm going to withdraw with the liberty to file a case if necessary.
How are you going to withdraw? You have instructions. You
Yes.
withdraw otherwise.
No, your lordship, succession case is pending there.
Understood.
And after getting the certificate, if the pensionary benefit gives me, because there is two dispute because I am the second wife
Second wife
of the deceased on a government employee. But the first wife was expired earlier to my marriage. Because of that, there is some dispute. Now it is settled. If the authority
the
concerned,
learned counsel appearing on behalf of the petitioner submits that he has instructions from the petitioner not to press the instant with petition for the present, taking into account that the question of issuance of the succession certificate is pending before
before the district judge,
the district judge.
Kamrup.
Kamrup. He, however, submits that in the circumstance the said goes he submits that in the circumstance that the respondent authority pursuant to the issuance of succession certificate does not take steps, he may not be precluded from filing a writ petition again. Taking into account the state submission, the instant writ petition and dismissed on withdrawal. However, liberty is given as sought.
15,
Yes,
This matter relates to my lord, non-release of my pension, my lord. During the pendency of the repetition, my lord, they have the provisional
non-release
pension
of
has
your
been
pension
provided.
after retirement.
My lord, after I retired on 36, 2020, my lord.
You retired on 36, 2020.
20, my lord.
Lucky enough. And not get the pension before 2. Yes, Mr. Sir. Why you have deprived the petitioner?
My lord, they have filed the affidavit,
Yes,
my lord,
Lordship,
disgruntled of
in-
police,
in my affidavit, Lordship,
paragraph number 7. my lord.
7, Lordship, categorically stated all these things, Lordship, what is the delay
Well,
regarding the
was an
delay of.
employee SP organization that petitioner is under trial.
No, my lord, no case against, him. No trial, nothing is against him.
There is a case.
No, no. I think some cases there in
Yes, there is a
connection with
case.
my book also might have, they have my lord seized by the police. I have not no related with any case. No proceeding has been done against me, neither I have been in police, any police case, my. Only thing is that my book has been seized by the police in 2011 in connection with differential.
Mr. Saronia, why don't you file an affidavit in regard to this paragraph 7 and say that there is nothing to reflect? I
My
think
lord,
that can be done.
my lord.
If we do that, then in that case, then I will direct them to, the problem is that it is there
Yes.
with the Chanmari, the court.
My lord.
Ask them to take either original, take Jimma of the document
Well,
or
Lordship.
take certified copy and process.
Why I have not filed my lord,
Certificate
this
copy
petition
receipt
filed in
pursuant to
2021.
paragraph
Now
8,
might have
Lordship.
developed
Huh?
by this.
Paragraph 8, Lordship. We received it.
The due to non-receipt of the original certificate, not being able to release the gratuity. That is what I'm saying.
However, this office has recently collected a certified copy of the service sheet from the CPA code, and the action is being taken to release the pensionary benefit to death or admission.
Then,
It is on process. Lordship.
oh, no, don't file it. I have-
That's why that is
That
step
That
of my
affidavit
on
was
process,
filed in
Lordship.
2021.
one.
on
my lord.
Have you got a provisional?
Yes,
My
he
lord,
got
provisional
the
I got,
provision.
my lord.
He got
After
the
filing of
provision.
this petition, I got.
You got provisional.
Yes, my lord.
CRG,
Others I am not
that
getting.
come retirement,
No, my lord, except provisional.
there is
nothing.
no cases pending against him. Then,
So far, Lordship, in this regard, Lordship, the process is on.
what process?
2 years gone, my lord. already.
What is this process is on from
No, because-
2021?
Lordship, after receipt of the certificate copy, Lordship,
Yeah.
the office started the process, Lordship.
Understood, you have, that was in 2021.
No,
That is your
let me
affidavit.
come along with.
When
let me-
you say that the
Yeah, yeah.
process is on, let us assume that the process started on 12th of January 2021 when you filed the affidavit.
Yes.
Then
Lordship, I have to take the instruction.
2 years have gone.
After Behu, Lordship, I'll fix the matter. I will come along with that.
Heard Mr. M. Karuni, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the state government.
Lordship,
For the director of
finance
pension,
is there also. I represent 1, 3, and 4, Lordship.
appears on behalf of the respondent number
1, 3, and 4.
3, and 4.
Finance is there, Lordship.
Finance, what problem? What is the necessity? No, nothing. You can strike off their name. Not necessary. I have thought about it yesterday or today in the morning. You see, in many matters, the finance have been unnecessarily dragged. Don't you think so?
I can if proper party so far as my lord the properties are concerned. Tomorrow if there is a charge of fund or any my lord scarcity of fund, then my lord requiring department or concerned administrative department would have to move to the finance department in cases.
No. the question that he has to pay, this department has to pay, is an internal matter between him and you. Nothing to do with the finance by you, what the petitioner has to say. Then why the petition, finance has to be made a party?
Tomorrow, my lord, allow the repetition, and then my lord, the contempt proceeding is drawn up for non-compliance of that order on account of the.
I understand. Tomorrow, there I have seen many matters where because of what they most I've seen in that day a matter where the PNRD was the department said that we have done everything. The finance has not given approval. And
Objection
for
raised
that,
by
the
the finance.
contempt matter has been disposed of. But tell me one thing. Is the responsibility of the PNRD department? They are not concerned. The petitioner need not be concerned with the finance department giving approval or not. Then why should this happen? Because otherwise, what is happening? First, finance doesn't have councils. They have only 2-3 councils. To get them getting is another big problem. Now, the second problem is, isn't it the responsibility of this, out here, the Home Department to pay? They don't have fund, take it up with the finance. But why does the petitioner have to take care of that?
The proper party, because my lord, at the end of the day, my lord, monetary benefits will flow to the petitioner.
So you have a role out there.
Proper party,
No. You have a role out there.
rule out there, my lord, subject to execution of the restriction. Because
Sometimes, my
otherwise,
lord, they raise objection, my lord. Bill prepared by the department, the finance raise objection. Then the department say we have nothing to do, only we have sent the finance department, they have raised objection, that they.
So in cases, my lord, where my lord regularization is great, or my lord, in cases where my lord cancelling of posts are.
No, I understand. Regularization is a concept by which you have to make the finance because of the fact that it is required under the rules of executive business to have that. Because without the finance approval, that can't happen. Or because of that 47/2005, that FRBM Act or something, that is required. But what is the requirement out here in this pension?
Apparently, my lord, finance do not have any.
And if the department here does not have the money to pay the pension, the close down or amalgamate with finance,
Now, it's one of the device. When
or is it something like the thing that earlier the government was having additional districts out here, and now you are thinking no, it is not feasible, for which you are trying to amalgamate the Nagaon district with Hosai, Vishwanath district with Sunitpur, and all these things. Why don't you have? Why don't these people amalgamate with you if they don't have the money?
This my lord, or providing the state, my lord.
And thereby they're causing the problem to the petitioners, to people. Isn't it more steps?
No, my lord, I don't think so, because my lord, finance is there, my lord.
But because of that, whenever anything happens, when they say that we have put it to the finance takes at its own sweet will, 4 months, 6 months we take. And thereby there is a delay.
For that reason, my lord, finance department can very well catch hold of the finance department in those matters, my lord. It can very well catch hold of the finance department in those matters, my lord, or finance ordinary delay. But my lord, at the end of the day, any monetary benefit flowing. Of course, my lord, in areas of pension, as well as my lord, so far as if considers come across the case yesterday, where the employee was of the finance department, that areas salary aspects was government. This picture. Of course, in those cases, my lord, those are employees of the finance department. But otherwise, my lord, in matters of pension, as well as in matters of area salary, these are all delegated powers.
Yeah, that is what.
These are all delegated powers.
Then why should the finance be made a party for these purposes? I'm not saying about that. Regularization, yes, necessary. New appointments, yes, necessary. Any other thing. But why do you need it for the purpose of these matters out here, the pension matters? Because the moment you are doing it, there are two. That is one problem is this: the finance becomes unnecessarily involved.
That may not be possible, not consider it, view the matter from that angle, matter, because finance is a because that cannot be decided immediately on the filing of the writ petition. Only on filing of the counters, it can be decided.
No. What does the petitioner, a pensioner, have to worry that about the finance? It is for the Home Department to take whatever it is
Home
necessary.
department or the administrative department concerned.
They have to take
Yes,
it.
of which the person concerned is an employee or was an
I
employee.
understand the accountant general coming in because they have to release it. But the finance is no rule there. Director of pension, yes. But what does the finance have to do? Because the moment you make this finance, that is the biggest problem out there.
There may not be any problem.
No, there are problems making the finance everywhere.
Because for proper adjudication, my lord, if at the end of the day, at the time of deciding a particular restriction, my lord, it becomes, court fine. Yes,
Yes, finance may be there for the purpose of treasury. There's a different aspect. But what does the finance department?
yes, department has the-
Finance department has done
And
no.
for the plain money, whether that money has been sanctioned by the.
Oh, no. The question of sanction doesn't apply.
not
If
that
you are in a regular post,
my
why you are not
Yes,
entitled to the
absolutely.
pension?
Otherwise, finance is required to where non.
Finance will only come only for the purpose of treasury.
Treasury and
Then if
plain
treasury is there, why not the state bank?
These are not non-plan money.
Nowadays, my lord, everything is disbursed for bank account.
That is what. Why not the bank?
Mine.
Why not that particular bank if you are making the treasury? Where will you get the money?
Otherwise, not necessary. Finance is not necessary, but it is interdepartmental, my lord. They have the class, my lord. Until under finance approve, they will not allow me to go to bank.
Problem here is that, my lord, when the case proceeds, my lord, proceedings are carried on. At some point of time, my lord, if it is found, my lord, or for proper adjudication, my lord, the finance is required there. Otherwise, there is no harm, my lord, in carrying finance to the court. Because lordship will be issuing directions from time to time to the concerned respondents who are concerned to comply with the order or who are required to carry out the function, administrative function under the law. These are the case in hand. In that you have the method.
No, you see, there is a difference between a necessary party, proper party, and no party at all. But if we have no role anyway,
No, that cannot.
necessary is home here.
No,
But what does the finance have to do here? Can you say that don't pay him the pension?
No.
You have no role out there. Then yes, the treasury may be given for the purpose of that. That is a different aspect. But the finance has no business out there.
My lord, lordship. Yes, that's my lord. That's not
Why I'm
necessary.
saying,
Mine.
because what happened earlier, at one point of time, you see the division bench which is there as regards what do you call those foreigner matters. I used to be the election commission counsel. Prior to that, what happened? There was an order being passed only for the purpose of intimating the electoral officer that in this case, the person has been, the order of the foreigners tribunal has been upheld or rejected. The reason is, the moment it is upheld, what was happening was, although these people were held to be, or their appeals, whatever may be, which were being appeal or writ petitions which were filed against the foreigners tribunal, these writ petitions, upon being dismissed also, nothing was done out there and these people were still voting. That was the reason, and for which there was a direction to give them a copy. That's all.
So that they can delete the name from the.
Only that. But what happened? The petitioner started to serve them copies.
Without
There's nothing. The ECI has no business of. How can they have any business in respect to an adjudication of a foreigners tribunal where they were not a party in the foreigners tribunal? They can't. But this is what is happening. one objection at that point of time. How can you make me? Because I have no rule. The basic idea was only to give him a copy so that he can communicate. Then look here, his name, this petition has been dismissed. Put strike off his name. That's all.
Right.
If you see Justice Bhuya, the order, I think he was sitting with somebody. That was the basic idea. And nowadays you see the ECI is the main party out there in all foreigners tribunal. Like we see the finance out here in all pension matters. Okay, we'll pass all that too.
Right.
You get it?
The authority tried to collect the duplicate copy or the copy of the service report, copy of the service report, but service book, but they had not collected the service report. The CBI was not provided at that time. They prepared one duplicate copy of the service book, and in that duplicate copy, Lordship, the birth year was the date of birth was written as 1960. Only year was written, Lordship. Date was not written, and therefore the policy is that if the date is not specific, then middle of the year the superannuation was he superannuated from his post, Lordship. It means the authority released the petitioner in the middle of the year. It means June, in the June 2020. But when received the certified copy from the concerned court, Lordship, it appears that his date of birth is 1st January 1960. It means according to the certified copy of the service book, it appears that his date of superannuation was 2019 31st December. Therefore, some excess period he did his work, Lordship, and therefore on this regard, some necessary original documents was required. The authority approached the petitioner to submit the original document, as well as the authority sent a letter to the higher authority in the office of the DGP for clarification on this point, Lordship. And therefore, some delays is there, Lordship. But he got the provisional pension as well as the leave salary. Whatever the authority now after clarification, Lordship, the authority will release its regular pension, Lordship. That is the difficulties after submitting
but all these things,
Lordship.
We see the communication which is annexure 1 to the petition. It shows that the petitioner's date of birth has been put at 30/6/2020, date of retirement. Although date of birth has been put at 60, page number 9.
Serial number 9.
Serial number 19.
Yeah.
Okay. Now, have you at all communicated to the petitioner at all about all these aspects of the matter?
Yes, Lordship. During preparation of the duplicate service book, Lordship, the authority discussed with the petitioner also. The petitioner also furnished certain documents because
when did you seize that his service book?
Lordship?
When did you seize his service book?
2000, possibly 11.
The CBI says this. The CBI, Lordship. Yes.
The cases of
Yes,
2011.
Lordship, it is on 14/9/2018, Lordship, report of CBI court. 14/9. Lordship, before 14/9/2018, Lordship.
We have seized.
No, CBI seized, Lordship.
Understood. CBI has seized.
If CBI
Now
has
they have placed it before the court.
placed it before the court on 14/9/2018.
Understood.
Means it
Now,
before.
when have you informed him that you are not releasing his because of the fact that there is some excess period.
Lordship.
You inform them?
Yes, Lordship, yes.
Well,
Lordship, after obtaining the certified copy, Lordship, from the CBI court, we asked the petitioner to produce the original one because it creates some differences. And therefore, the petitioner ever with that fact, Lord.
aware of the fact that, yes, there is a problem with the date of birth.
Yes.
But have you indicated that you are going to take any action for a recovery?
No, Lordship, regarding recovery, we are not going to that point, Lordship.
If you are not going to that point, then why you are not releasing him?
Yes, Lordship, for releasing the amount, Lordship, we send a letter to the higher authority, it means the office of the DGP, Lordship, for clarification, what to do on this regard, Lordship.
Then when did you send it?
Yes, Lordship, it was sent, Lordship.
When?
Only telephoning instruction I got, Lordship.
Only
Therefore,
telephonic only tell me when.
Lordship, that one I forgot to ask.
Yeah.
the officer.
But a person
Lordship,
has not
but
received it.
they are serious with this matter, Lordship. That is very
If
much
it is
serious.
serious, then in 2021, 12th of January, you have filed this affidavit. And then
subsequent
you say that
difficulty-
it is going on.
Subsequent difficulties arises.
So then
It's
how can you be said to be serious?
subsequent because
And these, what you are saying is nothing there in the affidavit.
but this affidavit was yes, Lordship. In this affidavit, all these things are not because it is the subsequent development, Lordship. After filing this affidavit, after filing this affidavit, all these things are subsequent. And therefore, Lordship, kindly take the matter after review, Lordship. I will submit all these things, all
Submit
necessary instructions, Lordship. As well as I also asked the authority that to do all the do the
He has to
whatever
get his pension and all this leave and
No, but-
all, what do you call, leave
Provisional-
encashment or whatever, maybe the TCRT
Lordship.
and all, he should get it.
lots of provisional pension he got, Lordship. And the leave salary also got.
What about the other one?
Other one, Lordship, due to
TCRT?
this difficulty, after obtaining the clarification from
No,
the
I know that why you are not releasing the TCRT. The reason is whether you are yet to take a decision to recover the excess.
no, Lordship, on
Then-
that line, Lordship, I cannot say at this
No,
moment.
no, that is the reason why you are not releasing his TCRT.
Not recover, but there's a-
And
No,
at
no,
a
no.
point of time, because unless he knows, how is he going to take any action further?
Let's take the matter after this,
The
Lordship.
fixing of the making of the duplicate copy has been done by you.
Done by me, Lordship.
So
At
if
the
it
same
has
time,
been done
Lordship,
by
with-
you have made
with
the mistake.
Lordship, with discussion with the petitioner, Lordship. That was because the petitioner was not the original employee of my.
So you mean to say you prepared the duplicate service book with consultation with the
Yes, Lord.
petitioner?
Yes.
Heard Mr. M. Colonia, the learned counsel, appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the respondent number 1, 3, and 4. And Mr. P. Borpuzari, R. Borpuzari appears on behalf of the respondent number 2. The learned counsel appearing on behalf of the respondent number 1, 3, and 4 had submitted that pursuant to the seizure of the service book of the petitioner by the CBI, a duplicate service book was prepared, wherein the date of birth was not reflected except the year of birth has been reflected. Taking into account the long-standing practice, the date of birth of the petitioner was taken as 36/2020. 36/2020.
Retirement.
However, upon getting the certified copy of the service book from the court of the
CBI.
CBI, Assam, came to light that the date of birth of the petitioner was 1/1/2060. Under such circumstances, certain clarifications have been sought for from the Office of the Additional Director General of Police,
DGP report. Director General.
from the Office of the Respondent number 3.
Lordship.
And as such, the said instructions are awaited. It is relevant to take note of that the respondent number 3 is relevant to take note of that the Director General of Police Assam is the respondent number 3 in the instant proceedings. It is also pertinent herein to mention that the petitioner retired as on 36/2020, retired on 36/2020, as could be seen from Annexure 1 to the petition, as well as the specific affidavit, as well as the averments made in the affidavit filed by the respondents. So, considering the above, that the petitioner have retired on 36/2020, this court grants the petition, the respondents time to bring on record all these aspects of the matter which have been submitted by Mr. Goswami, the learned counsel appearing on behalf of the respondent number 1, 3, and 4 by way of an affidavit. And also in the said affidavit, the said respondents are directed to indicate as to what is the status of the final pension. And you have not made the director of pension a party. Unnecessarily, you have made the finance a party. That also indicate as to the status of the pension of the petition, pension of the release of the pension, as well as the pensionary benefits of the petition. It is also seen from the records that the director of pension has not been made a party in the instant proceedings. Taking into account that the director of pension is would be the presence of the director of pension would be relevant for a proper adjudication of the writ petition. This court impedes the director of pension having his office at House 12, Guwahati 781006 as the respondent number 5 to the instant writ petition. The registry is directed to correct the records on the basis of the instant order. Mr. S.R. Borua, who is present in the court, duly accepts notice on behalf of the newly implemented respondent number 5. The learned counsel for the petitioner is directed to serve a copy of the writ petition along with the copy of the affidavit filed by the respondent number 1, 3, and 4 to the learned counsel appearing on behalf of the newly implemented respondent number 5 during the course of the day. No, let him appear for the police.
Hello,
You appear for the.
SS
There's a
Borua
reason why.
SS Borua is there. Mrs. SS.
What? No, Mr. S.R. Borua, doesn't he appear for the director pension?
Yes, he can.
Then
No,
you are finding somebody else.
I love it.
Or leave the matter on 26th of April 2020.
Matter number 17.
Yes, Mr. Naik, you have filed the affidavit.
Yes, doctor, I have filed.
Yes, what is required out here to be done today?
Lordship, today most probably it is not in the record, Lordship.
Oh, you are respondent number 5?
Yes, doctor.
Respondent number 5 affidavit is there?
Yeah, respondent number 7 has filed, Lordship.
Or this respondent number 5 has filed?
Lordship,
You are appearing for whom?
My submission will be, Lordship. Here, Lordship, I found in the affidavit, Lordship, some points are not covered and they are likely to be covered by the petitive authority at the top, Lordship.
Oh?
It was filed by the executive engineer. So I think some more instructions are
to be obtained.
Case pertains to what?
Well, this is a matter pertaining to compassionate family pension. So if we find the scheme that is the compassionate family pension,
Huh.
it starts from page 54 and it
Huh?
will be 14.
14/7/2017.
17, my lord.
Yes.
Relevant portion on the ground on which they are rejecting is at page 55. It says, however, the government servant must complete minimum 1 year of continuous service without break before death while in service. They're saying I did not complete, the husband of the petitioner, he did not complete 1 year service, rather he completed 4 months, 12 days. And the case of the petitioner before your lordship is that he was initially appointed in pursuant to an advertisement issued by the BPC authorities. He appeared in the written examination. He was called for in the interview, and he was appointed substantively against the sanctioned vacant post, but he was kept on a fixed pay. Initial appointment, that is of 2011, and that continued because in the year 2018 they have passed an order granting him regular scale of pay. So the case of the petitioner before your lordship says that that period has to be counted while counting this 1 year of service.
You are appointed as what?
My lord, initially appointed as, my lord, LDA. That your lordship will find the advertisement, my lord. I'll just take advertisement, my lord will find
LDA.
yes, my lord. Page
Then-
29, annexure P1. Junior
No, no, where's your appointment letter?
appointment letter, your lordship will find.
Order
Yes, my lord.
2011.
Yes, page
In
39.
pursuant to so and so, so and so, so and so, the following persons are hereby appointed at the sick pay on so and so per month from the date.
Serial
Whereas
number
the submit a medical certificate that the candidate shall join in the place of sick immediate. The appointment is here and may be terminated at any time without signing any reason. Then,
Page 42, 28 serial number is the petitioner.
yes, then
Then, my lord, he continued, and then thereafter he joined in that post, my lord, junior assistant, and then page 46 is the order. By which
no. What do you say about page 46?
it is, by this order, he has been granted the regular scale of pay.
No.
Page
You
40.
see, I am directed to state that the Boroland Territory is pleased to approve for appointment of the following 7 fixed pay employees
Yes.
of entrusted Department of BTC in the vacant sanction post.
Yes.
Meaning thereby, you have been appointed only against sanction post then, not before that.
This was a regular, there was an advertisement, Miller. How can there be an advertisement?
Oh, advertisement happens long. I've been busy with taking up this medical matters. These advertisements keeps on happening, more particularly with this. You were appointed against a vacant post
Yes, my lord.
initially.
Yes, my lord.
How do you say?
A lordship will find the advertisement, my lord.
Yes, show me.
Page 29.
Hmm.
5th March 2008. Applications are invited from Indian citizens so and so.
Filling up the vacant post lying in the council.
Yes, my lord.
Head of the department office, district so and so, as per the details of the post given below. Where?
Yes.
So we have to see as to whether there was vacant sanction post at that point of time. Who is appearing out
It
here?
says about the vacant post. It says about the
Mr. Naik, what affidavit you have filed? There was no vacant sanction post.
No, it is mentioned as vacant post, but not mentioned that it is a sanction post. It may be fixed pay also, temporary post also. There may be vacant temporary post. Fixed pay. From the appointment letter also, your lordship know where to find it, the vacant sanction post.
There the problem arises.
There was a-
Otherwise,
there was a-
otherwise, why was it required? Because what you are trying to say is that you have been given a regular scale of pay. No, it is clearly written out here, please to approve for appointment. of the following so and so fixed pay employees against vacant sanction post. Then why are you not reading that aspect of the matter?
No, that's true, my lord. It is
Then-
written there. I'm not
Then how
saying,
do you take the earlier period of service?
my lord, this, my submission before your lordship is that, my lord, think the case of, my lord, completion of family pension. There was an advertisement.
But
I
Mr. Das,
participated in the
kindly tell
selection.
me one thing.
My lord.
Do you enter the category if you are appointed against a non-sanctioned post? No.
But it is nowhere there, my lord. At no point of time, my lord, if you lordship kindly see the communications, even it is clarified by the, when the BTC authorities wrote to the chief engineer, they were also aware, they sent the proposal that he was appointed as a fixed pay. It is not, my lord, denied anywhere. But the
Then
thing
why is
that-
it written out here that against vacant sanctioned post? If there was a sanctioned post out there, then it
That is
would have been
also-
different out there.
The same question, my lord, I asked
Then-
myself also, my lord, when there is an advertisement, there is a written examination, there is an
No,
interview.
when you
there is a
ask you ask your client, does it mean that there is a right out there? No,
Unfortunately,
you
my lord,
have to show this court on the what basis you are saying that it is a vacant sanction post. Because why? Earlier you were appointed as what?
LDA, my lord.
Where?
You know, the advertisement was for the lordship will
Okay,
kindly see the
LD
call letter.
Not LDA, junior assistant.
You know, LDA stroke junior assistant, lordship will kindly see
Understood.
the
But
call
no,
letter.
it is
page
mentioned as
33.
junior assistant LDA, grade
Yes,
3.
Yes, my lord.
You were
Junior-
appointed against this post.
This is the call
Now let
letter.
us see your appointment letter. Where is it?
It's my lord. Select list is there and appointment letter, page 39, my lord.
39.
Yes, in
Okay.
pursuance to letter number so and so BTC so and so from Under Secretary Personnel Department BTC Kokrajhar and letter number so and so from the Joint Secretary Transport BTC, the following persons are hereby appointed as LD Junior Assistant stroke LDA on fixed pay of rupees so and so per month with effect from the date of joining duty. The appointed person shall submit a medical fitness certificate from the Joint Director Health Services of the district concerned. The candidate shall join in the place of posting immediately. Thereafter, the petitioner joined, and prior to that, there was a select list published, my lord.
Where is your petitioner's name?
A petitioner's name, your lordship will
Was
find
at
page
28,
number, serial
Office of
number
the
28.
Junior Joint Commissioner of Transport, BTC Kokrajhar.
Kokrajhar.
Okay. Now, in this case, this was there, you were appointed, these are all transport department,
Yes, my lord.
but you have been later on absorbed in the water resource
Water Resource
department.
Department.
But whether there was a sanction post, because if it was a sanction post appointed, then how can you be terminated without assigning notice?
There was no termination, my lord.
No, no, can it be? Because you see the language of page 39.
Yes,
The
my lord.
appointment is purely temporary and may be terminated at any
That's
time
true, my
without
lord. That's true.
assigning any reasons.
That's
Then
true, my lord. That's
if
true.
that
It
be
is there.
so, you were not at all confirmed.
That line is there, but what my submission is that, my lord, is there was an advertisement and that advertisement says that there are vacant posts. And I was called for written examination.
Vacant post, but whether there was vacant sanction post. Because that is why you have not been, you have been given a place of posting. You are not given a place where you have to join. See the page 39. Place of post, the office, you are asked to join out there in the office of the district area. Unlike page, the other appointment order where you have been directly out there to the
You know,
against vacant sanction post.
My lord, the issue is that, my lord, after the selection is held, my lord,
Hmm.
where I'll be posted, my lord, that is not within my domain.
Okay.
The advertisement says, my lord, etc. for recruitment and filling up a vacant post lying in council, head of the department, offices and district and subdivisional offices of BTC area, my lord.
Very.
So advertisement says so, my lord. I participated in the selection process, my lord. Thereafter,
Okay,
they have-
okay. Today should not be proper to dismiss. You file your affidavit, pointing it out as regards whether there was, you are BTC, na?
Lordship.
You are the main person involved.
Lord.
You have transported him to him. So you file your affidavit indicating as to whether there were any vacant, these posts were vacant sanction posts or not,
Initially,
against which the petitioner was initially appointed.
Government has already filed an affidavit matter.
Hmm?
That let me record it. Government has already filed an affidavit.
I've seen it.
Right.
You have filed it,
Yes.
I think respond number 5.
No, Madam, respond number 1 and 2.
No, there is an affidavit filed by respond number
Respond
5.
5. Here, 5.
Yes.
Madam.
Who happens to be the chief engineer.
Yes, chief engineer, but he has also communicated, he was communicated the decision of the government. Government took up the matter at appropriate level. Annexure 2.
No, the problem arises with you is
Yes.
you have been only in your place. He have been permanently absorbed.
Right.
But absorbed only for, he was there only for 4-5 months.
Right.
So your knowledge will be only limited to that. I think the BTC needs to bring on
Yes,
record as
yes,
to regards the
certainly,
advertising.
certainly. As
But
the
Mr.
lordship
H.K.
has,
Das, the learned counsel appearing on behalf of the petitioner. Mr. P. Naik appears on behalf of the petitioner. And Mr. Swami appears on. You are appearing as the water resource or the
yes,
additional
Madam,
advocate
government
general?
respond. Respond number
Mr.
1.
So, Mr. Goswami, are you appearing as the standing counsel of water
No,
resource
Madam,
or
as
additional?
additional advocate.
Addition.
Madam,
Also
respond number 1,
appears-
2. Respond number 1, 2, 5.
Appears on behalf the additional advocate general. Assam appears on behalf of the respondent number 1, 2, and 5. It appears on record that the affidavit in opposition has been filed by the respondent number 5. Mr. P. Naik, the learned counsel appearing on behalf of the BTC submits that there is already an affidavit filed yesterday. However, the same is not on record. He, however, submits that he would require to file an additional affidavit as various points have not been taken care of in the said affidavit so far. Taking into account the same, let the matter be listed again on 8th of May 2023. In the meantime, the BTC shall file the additional affidavit. In the said affidavit, the BTC shall also clarify as to whether in the advertisement dated 5th of March 2008, the posts mentioned therein were vacant sanction posts. Yes. Oh, that matter. You got anything in instructions?
Instructions, my lord.
This is the matter which came back from division bench.
My lord, my lord.
Okay, then.
My lord, I got the instructions not in a formal way, my lord.
Huh?
All the orders they have sent me, my lord. My lord, I just could not get a formal letter from the department, but I got all the review orders and, my lord, the suspension extension orders till date in serial, my lord. It is there. So I'm
Does it help this court or no?
yes, my lord. That is what my lord has last time.
Then
That is what my lord has indicated on the last occasion. That
taking into account the above fact, learned Mr. Dhawar, Council Mr. is directed to apprise this court on the return as regards the status of the present departmental proceedings and as to whether there has been any further review to the suspension order, taking into account that the order dated 8/11/2021. The period of suspension of the petitioner was only extended by 3 months. Now, what is happening? This one, you have extended periodic reviews.
yes, my lord. Yes, my lord. It is all there, my lord. On the last order,
The
is, my
last
lord,
one is of 9/3.
9/3, my lord. It is still in force, my
Decided
lord.
to extend the period of suspension in respect of Ronak Ali. Who is Ronak Ali? Or Prasanna
My lord, it is in serial number 4.
Huh?
Serial number 4. There are
Decided to extend the period of suspension of what is his name?
Prashant Datta.
Santa Datta by another 3 months as department proceedings are in progress. The meeting decided to extend the period of suspension of so and so by another. Recommended suspension of Prasanna Datta was placed under suspension under remand has been extended till 9/6/2023. Very well. So this has been extended from time to time.
Yes, my lord, on regular
Okay.
basis.
Now what to do?
My lord, if you go by Ajay Chaudhary, the second part, my lord.
Hmm.
Then, my lord, they have to challenge this continued thing, my lord.
Mr.
My lord, my lord,
Mr. Patwari, do you have any other ground out there for challenging?
My lord, Major Lordship knows, my lord, on the very first day it was disposed of, and this got an appeal that order, but otherwise the coordinate bench reinstated the
Hmm?
Otherwise the coordinate bench of this honorable court, the direction was there to reinstate the
Who?
My lord, a coordinate bench already passed a reinstatement order.
Okay, but that has been set
Yes,
aside.
that has been
So
set
matter ends there.
Yes, sir. Now, my lord, if there is an extension, probably they need to file, bring it on record by way and affidavit. So that
Oh.
it can be filed.
Very well.
I filed my.
Mr. J. Patwari appears on behalf of the petitioner. Mr. Ardhar appears on behalf of the respondents. In pursuant to the order dated 22/3/2023, passed by this court, the learned counsel appearing on behalf of the respondents, Mr. Ardhar, submits that the suspension of the petitioner had been periodically reviewed and the last of such review had taken place on 9/3/2023, whereby the period of suspension had been extended by another 3 months as the departmental proceedings are in progress. In that regard, a notification dated 9th of March 2023 have also been issued by the Joint Secretary to the Government of Assam Home and Political Department. Taking into account that there has been certain various periodical reviews, this court is of the opinion that all these documents should be brought on record by way of an affidavit. So accordingly, let the matter be listed again on 21st of April by the the petition. The respondents are directed to bring on record these orders of review as well as the minutes of the periodical meeting by way of an affidavit by 19th of April. I am not taking all this on record. You
I will
bring it on record.
record.
Mr. Chaudhary, why don't you try to bring out a case on unnecessary delay?
Yes,
Try to bring out a case.
in fact, my lord, that is our case. Even my
No,
lord,
no, forget about Ajay Chaudhary,
Uh-huh.
but say
no,
on unnecessary, because they have been continued.
from
This is a case of
21,
initial was done in 2020.
June 21,
or
June 21.
No, before that.
8/6.
No, the first review happened
17/6/21 is the date of suspension.
17/6/2000.
First review, they did it on 8/11/21.
8/11/2021. So they have been almost 2 years have gone
No, my
by.
lord, I think lordship will also have to take note of one fact. If this is how, my lord, the suspension continues, then it is punishment.
Yes,
Without any proceeding, you have punished me.
So the learned, another line, huh? The learned counsel appearing on behalf of the respondent, the respondents are further directed to indicate in their affidavit as to what is the stage of the departmental proceedings and by what time, let's say, departmental proceedings are likely to be completed. I think then we can take a fair call on the next stage.
And my lord will kindly give us the liberty to ask all the law points, my lord. On next day, I'll argue everything.
As of now, if you want to argue, we can argue to that, but only we don't have that. Because he said only that Otherwise, I always
My lord,
keep these
instead-
on record
My lord, would
by
it be-
way of an.
Would it be before any day of this, 10, 11, 12, 3 days appear?
Mr. Chaudhary, I would love to take it, but the problem is you see the status. Today I was supposed to sit at 2, but I was pulled from there and I was seated, taken to some meeting
My lord,
and I
can we-
had to
can
see
we
that.
take a chance, my lord, on
There are
11?
many courts which I don't think are sitting in the second
No,
half.
my lord, can we take a chance, my lord, 11?
You can bring on time.
11.
My lord, 11, I have to file the affidavit also, my lord.
আরে বাবা, আজি কিমান তাৰিখ? দুসপ্তাহ আছে।
Okay, we don't disturb you with the affidavit. I put this on record by with the annexure.
Yes.
He only asked for affidavit.
My lord, 11. Not 11, my lord. 11th, I have some difficulty. Either 10th or.
We'll have it on 20th.
12th, my lord.
Instead of that, I fix it on 20.
20.
20. I think that is a bit. 20. You file it by 19.
So I will do it, ma'am.
Deeply.
36.
कागज Ken Chaudhary लिखी थी। Ken Chaudhary Senior Counsel assisted by Mr. Tape. Yes.
May it pleases your lordship, my lord, this is a matter of financial upgradation of the petitioner. Finance department was supposed to give instructions as regards the up-to-date.
Oh, here, there. You see, the finance is not here.
Lordship,
Huh?
I'll be
Finance
appearing,
taxation
Lordship.
department.
Finance
You,
taxation.
you appear for finance and taxation.
Yes, Lord.
And what is this?
Finance
Oh,
and
this is the Department of Finance. Oh. Now, what about the Department of Finance? You appear for the Department of Finance and Taxation.
Assam taxation finance. I think they are the standing council.
No, he's not the standing council
Is the
there.
standing council, I think.
No, finance is different. That is what all was going on prior to, yeah. Finance is very difficult to find. Yes, there he comes.
I am all along sitting.
Yes,
Well, this relates to financial
yeah,
update.
there's the finance filed the affidavit.
No, they have not. In fact, on the last occasion, there was a submission that they are already forwarded the case of the petitioner and it has come back for certain clarification. So this court wanted to know what is the up-to-date status.
Mr. M. Bhuyan, the learned counsel on behalf of P. Gugoi, the learned counsel have submitted that Mr. Gugoi has not received instruction in deference to the order dated 19/9.
19/9, your lordship will kindly see.
Mr. Gugoi has on instruction submitted that the proposal for financial upgradation pertaining to the petitioner submitted earlier has been returned to the department seeking certain clarification. He has therefore sought the matter to be listed after puja.
My lord, nothing has come so far.
We
my
have
lord.
it after puja.
No,
then.
my lord.
Well, yes,
It's
what
a very
instructions
short
you have?
point because
Have you sent it again?
Lordship,
The
again, it
proposal.
was sent on 7th of November 2022.
Hmm.
Thereafter, Lordship, I talked with them in the morning, Lordship. They have given me a letter whereby the finance PRU department has returned it back to the taxation department to give it in proper format. And the communication was sent to the Commissioner of Taxes on 28th February 2023. And Lordship, they have prepared it and they have the Commissioner of Taxes has asked me for 10 days time. They will be forwarding it again to the finance, to the government, Lordship.
Now,
for the
which one?
necessary,
Finance
approval.
PRO or finance budget, finance establishment? which
Lordship,
one?
to the government, then it will be forwarded to finance PRU
Yeah.
unit, Lordship.
So the PRO will do approve the proposal.
Lordship, it's up to them whether everything is if everything is in okay, Lordship, then only they will approve it.
What is this proposal business?
alert, this is relating to the modified assured
Are
carrier.
we in the realm of the absolute discretion of these authorities?
no, my
Or
lord,
do you
no.
have any other case?
I have, my lord, I'm entitled under the scheme for a benefit, my lord, because I have not got 2 promotions within 20 years of my service. They were duty bound under their proposal to send my case within that year, which they have not done, my lord. I have filed several representations and I'm before this court, my lord. This is
Right.
how I have come.
So
my lord.
you have a case.
I
So why
certainly
should this
have a
court
case.
wait for all these
Very well, my
proposal
lord. I'm
business?
before your lordship. If your lordship wants, I can place the documents, my lord. I was appointed as an inspector of taxes on 7th.
Oh, you want under the modified?
My lord,
Very well. What is your case? Why you have not been given? You have completed 10, 20, 30,
No, I have
which one?
completed 20 years, my lord.
You have not even given the 20 years.
I have not given 2 promotions. If I don't get 2 promotions in 20 years, my lord, I have got only 1 promotion. So since I didn't get 1 promotion, 2 promotions total, therefore I'm entitled under the scheme for a financial upgrade.
1.
Yes, 1. This is what they have not given me. I was entitled way back in 17. From then I have been fighting, my lord. In fact, in 20, another person who was appointed with me in 97 has got, but I have still not got mine.
Okay.
So arbitrariness is very much there, my lord. In fact, under the
Let
scheme,
us see your case.
my lord, just 2 documents if your lordship
it is.
allows me to show, my lord. One, your lordship kindly see.
You got your first promotion when?
My lord, that I got on 19/12/16. Sir, if your lordship kindly takes
So
page
19,
41.
12, 16.
My lord, if your lordship kindly takes page 42, that entire chart is there.
Okay.
My name is there. Then your lordship will see I entered service on 15/5/97. Then your lordship will see the remark. I was promoted to Superintendent of Texas 17/12/17. So this is one promotion that I have got, and I have completed 20 years of service in 2017. Therefore, I'm entitled for 1 benefit under the scheme.
You should be entitled to 2.
No, I got 1 promotion, my lord.
Oh, that is what?
That is fine. Now, if your lordship kindly comes to the scheme, that is at page 37. Your lordship will kindly see. This is at page 37. Your lordship will see the benefits under the first salient features of the scheme. Roman 1. MACPs would include grant of financial upgradation 3 times in the entire service period. That is, on completion of 10 years, 20 years, and 30 years, to those employees who do not get 1 regular promotion within the first 10 years, or 2 regular promotion within 20 years, or
No,
3.
in that chart it is given now.
Yes,
20 years,
yes,
A, none, 2 increment.
yes,
B, 1 increment.
yes.
Matter ends.
Matter ends.
So why should we wait for the sweet will of the finance? Okay.
Absolutely,
Because
my lord.
finance does not file affidavit.
After several times I've been given.
Heard Mr. K. Goswami, the learned counsel appearing on behalf of the petitioner, and Mr. E. Chaudhary appears on behalf of the respondent number 1. Then?
And 5. That's it.
1 and 5. Mr. R. Babuzari appears for the respondent number 2, 3, and 4. The case of the petitioner is that the petitioner was appointed
Seven 597.
by an office order dated 30/5/1997.
No, that is not the appointment order. Appointment order is at page 20. 7597. This is the release order from mandatory training.
Was appointed on 7/5/1997. Temporarily on probation as the inspector of taxes in the regular scale of pay. Plus other allowances as admissible from time to time under the rules with effect from the date of joining at the Assam Administrative Staff College, Khanapara, Guwahati.
Then I was confirmed at page 34.
Subsequent thereto, where page
34. 34.
Subsequent thereto, on 30th of May 2014, the services of the petitioner was confirmed in the cadre of Inspector of Taxes without prejudice to her seniority with effect from 5/2/2014 against the existing permanent vacancy.
then promotion 35. The superintendent of taxes.
Thereupon, on 17th of December 2016, the petitioner was promoted and appointed temporarily as the superintendent of taxes until further orders under Regulation 4D of the Assam Public Service Commission (bracket limitation of function) (bracket close) Regulation 1951 in pay band 4 of rupees 12,000-4,000 with rate pay of rupees 5,400 plus other allowance. Thereupon, the petitioner joined a promotional post on 19/12/2016. Next. The case of the petitioner herein is that the government of Assam had introduced the modified assured career progression scheme, brackets MACPS, bracket close, dated 6/7/2017. In terms with the said scheme, it shall include grant of financial upgradation 3 times in the entire service period, with on completion of 10 years, 20 years, and 30 years to those employees who do not get 1 regular promotion within the first 10 years or 2 regular promotion of like ACPS benefit within 20 years or 3 promotions of like ACPS benefit within 30 years of regular service. There's an illustration given in clause B Roman 4 of the modified assured career progression scheme notification dated 6/7/2017, which clearly would show that for 10 years, if there has been no promotion oblique ACP benefit oblique MECP benefit availed, now if the length of service is 10 years and there is no promotion oblique ACP benefit oblique MECP benefit availed, then the person concerned would be entitled to 1 increment. However, if there has been a promotion within the period of this 10 years, oblique AC or had taken ACP benefit oblique MECP benefit, then there would be not that then the employee would not be entitled to any increment. In the case of 20 years of service, if there has been no promotion oblique ACP benefit oblique MECP benefit, then the entitlement would be for 2 increments. However, if there is 1 promotion oblique ACP benefit oblique MECP benefit availed, then the entitlement would be for a further 1 increment. The illustration at para B Roman 4 being relevant is, which is in a tabular form, is extracted here in under. It appears on record that the petitioner's date of service, entry into the government service, was on 15/7/1997. And her total length of service as on 1/1/2018 was 20 years, 5 months, 17 days. The petitioner had got only one promotion to the post of Superintendent of Taxes on 17/12/2016, I suppose, na?
Yes, 17/12. 17/12.
17/12/2016. However, the petitioner had not been given her increment. Her addition, however, the petitioner had not received one increment, which she is otherwise entitled to in terms with the notification dated 6/7/2017. It is because of the said the petitioner is before this court. The petitioner has also to the writ petition enclosed an order issued by the undersecretary to the an order, a notification dated 24/3/2021, wherein a person who was appointed as the superintendent of taxes on the same date on which the petitioner was appointed as the inspector of taxes have been granted one increment, one financial upgradation, after taking into account that he had got a promotion on 29/1/2020. The petitioner therefore submits that action of the respondents in not granting the financial benefit which have otherwise been granted to others violates the mandate of Article 14 of the Constitution. It appears on record that this court had issued notice on 28/6/2022 while issuing notice. This court also made it clear that pending disposal of the writ petition, there shall be no bar in considering the case of the petitioner. It appears on record that the respondents have not filed their affidavit although the matter came up on 19/9/2022, again on 31/10/2022. It is relevant to take note of that on 19/9/2022, the Learned Standing Counsel for the Finance Department had submitted that the proposal for financial upgradation pertaining to the petitioner had been returned to the department seeking certain clarifications and has therefore sought that the matter be taken up after the puja recess so that he can update on the status of the proposal. Today, when the matter has been taken up, Mr. B. Chaudhary, appearing on behalf of the respondent number 1 and 5, submits that the same respondents had again submitted the proposal, which was again returned back by the finance PR of the department. And the finance PR, and further to that, the respondent number 1 and 5 had again submitted the said proposal. I've heard the learned counsels for the parties and have also perused the materials on record. As already stated here in above, the entitlement of the petitioner in terms with the notification dated 6/7/2017 to 1 increment, to 1 financial upgradation, taking into account the petitioner have already got a promotion on 17/12/2016, and as of now have completed more than
25 years.
what 25 years? Oh, 25, 26 years.
Yes, as on date, she's retired already. And total completion of service,
When did she retire?
she retired on 36/2022.
Taking into account that as of more than, you just give me the as of as on the date of the retirement of the petitioner on 36/2022, he had completed this. This court finds no reason why the respondent authorities should withhold the upgradation, the financial upgradation to the petitioner from the date of his of her entitlement in terms with the notification dated 6/7/2017. Further to that, as the petitioner have already retired with effect from 1/7/2022, it is also required that a pensionary pension has also to be. Have you made that prayer or not? Don't tell me you have not made that.
Because we filed this petition before retirement.
So you want to file another petition?
Your Lordship, that's 226, my lord. Your Lordship could certainly put that.
That MSCP scheme at page 39 of the writ petition, it is a part of the scheme. But the procedure for granting financial application, procedure has been laid down. But there has to be a screening committee. And my lord, this is my lord further modified by my lord, and
these are the procedure.
Notification, my lord, dated, my lord, that is 9/3/2019. My lord, in the notice by the finance department, since they have sent a proposal, my lord, that proposal was returned, my lord, with an endorsement that it should be sent in accordance to this notification. Now, this notification, I have just now find it, my lord, in the internet. Some, my lord, procedural changes with regard to, my lord, how to grant it, the procedure.
No. The fact that she is entitled is not in doubt.
So, my lord, but the procedure has.
No, procedure has not been done by them. No, tell me one thing. If there is a fault on the part of the department not to do it, can you blame the petitioner?
No, I am not on that, my lord.
No, the question that what is required as of now, that is why I will, whatever it needs to be done, do it. That is what I'm directing.
Yes.
But you have to do it within 3 months.
Yes, my
Grant
lord.
of all the benefits.
Yes, my lord, if you want to peruse this, my lord, I can hand
Yes,
it. But
what is it?
otherwise, it is a, my lord, amplification of that clause C in page 39.
The clause B, they were duty bound to consider every year. They have to give shortlist this candidate for entitlement, if they have not done.
What is the difference?
And here at page 39, there is no mention of, my lord, class 1 or class 2 officers. But in that letter notification, there is a mention of class 1 and class 2 officers.
Then
But if the petitioner within the ambit of any of those class officers, my lord, then that procedure has
the
to
purpose is of 2019 was done for simplifying the proposal.
be simplified with regard to class 1 and class 2.
Whatever may be to simplify.
No, but
Earlier it was found to be more cumbersome. That is why it's
it is simplified. Now, therefore, my lord, my respectful submission, if the petitioner comes within class 1 or class 2, my lord, he will be governed by that 2019 notification so far as procedure is concerned, my lord. Because there has to be a
No.
limit.
This, if they have not done it, you have not done it as per this 2019.
Lordship, it has been done as per the relevant notification, but the placement, I would say placement in the format was not proper. Why, and for that reason, finance PRU has written in fact with the format. They have given a format, Lordship, that it has to be filled up in that format.
No. Are you not supposed, even by both, on 1st of January of each year to look into it, whether the person concerned has completed 10 years, 20 years?
Yes, Lordship.
Then he has completed his 20 years.
That's true, Lordship.
A person is entitled to this MACP on completion this 10 years, 20 years, and 30 years. Which is being given out there.
Automatically, it has to be forwarded, Lordship, before the
No,
appropriate
if there is
authority.
a fault on your part where the respondent number 1 and 5 does not know how to send it, but knows how to send it for others first, but not for the petitioner. What do this court otherwise has to assume? Because for other person got it, the reason why the petitioner have not got it. If it is the same department, where you can very well send it for another, the finance PRU department has no problem. Why it is in the case of the petitioner they have, I would have understood the respondent number 1 and 5 may not know. But in respect to the same department, the respondent number 1 and 5 has done it, and the finance PRU department has no objection.
Why there was a different manner of procedure
Then-
adopted? Lordship,
And
that I
it has been only done one on 2021.
Yes, Lordship. I
Then-
have seen it.
What is this pick and choose method? Yes, you have done it. The pick and choose. Now then why the respondent number 1 and 5 has done for another person? You have allowed it. And for him, you say that the format is wrong.
Definitely, there has to be a format. my lord.
Understood. If that be so, why not for the earlier one? There's no format for him.
No, earlier one, my lord, perhaps, my lord.
Maybe the
it-
format has changed,
com-
maybe,
complied.
and
It
it
has
may
been
be there,
complied.
Lordship.
It has
When
been
did you
complied.
change the format?
Format, it is not there.
I
Don't,
was entitled way back in 17.
Lordship will see this endorsement.
My entitlement was way back from 17, my lord. I completed
Yeah.
20 years then. As per the scheme, I should have been considered by then.
Yeah.
On some
This was,
reason or
because
the
if you
other, they
see
were not
number
doing
two,
it
read it. Number 2 and number 3, it says every year,
every
the
year.
January of each year.
So that is why
They got it in 2017.
I'm praying for mandamus because they have failed to perform a duty which they were supposed to perform under the
Illegal
Act.
last. Is also required that on the basis of the said financial upgradation to which the petitioner has been held to be entitled by this court, and there has been directions to the respondent authorities to release the pension of the petitioner has also to be accordingly. The pension case of the petitioner has also to be accordingly taken, processed on by taking into account the said financial upgradation as directed herein. Mr. B. Chaudhary, the learned counsel appearing on behalf of the petition, respondent number 1 and 5 have submitted that in the meantime, the finance PRO department had sent a format by which the proposal has to be sent. And said respondent number 1 and 5 are taking, are in the process of sending such proposal in that manner. Taking into account the same, this court therefore disposes of the petition by holding that the petitioner would be entitled to the financial upgradation financial upgradation from when?
But with effect from 1st January of that year. This is given at page 39. So on the year when I complete
No,
my
as
20
per
years,
you, Mr. Borpuzari, his financial upgradation would be from when?
as per page 39 from the year of my entitlement, that is 2017.
That is your page 39 is the problem where there is an amendment, no?
Amendment of the
Where,
My lord comes to, if my lord comes
is to order granting the benefit of financial upgrade with effect from 1st January of that year. Then,
page 42 of the writ petition may kindly be changed. Page 42.
yes.
This is the statement, my lord, of the particulars of the petitioner. There, my lord, will see, come to my lord, column 5. Number of promotions avail up to 111. Number of benefits under MSCP is due as on. So this will be the date. 1/1/2018.
1/1/18, madam.
With effect from 1/1/2018.
Yeah, it is there. Great.
1/1/2018. Number 2, the respondent number 1 and 5 is directed to coordinate with the finance PRO department of the government of Assam so that the petitioner is released the areas accruing on account of the financial upgradation so directed herein above. Expeditious. This court grants how much time?
Also 3 months from the date of receipt of the order.
Why both of you are here?
The certified copy is required. from the date of receipt of a certified copy.
We give you a copy.
That whole entity, my lord, certified copy, that the petitioner, we will communicate, otherwise, my lord, no difficulty.
Within 3 months from the date a certified copy of the instant order is served upon whom?
My lord, to the respondent
To
number
the
5.
Commissioner of Taxes, Assam. That's respondent number 5. Number 3. The respondent number 1 and 5 further upon further shall also process the pension of the petitioner, pension proposal of the petition by taking into account the financial upgradations so granted herein. Here it will go to the accountant general or whom? For your department or the director of pension?
Accountant general.
Huh?
Accountant general.
It will be the accountant general. The accountant general is not a party respondent.
Not necessary. He will file with petition later on. It doesn't happen. Or contempt. With the above the petitions that
Deeply, right. Year is 25 years, 1 month, 50.
yes, so many mention memos, whose case it is. Yes, Mr. Kaim.
In this case, I am claiming for minimum pay of the pay scale.
Oh,
As per open das case.
why you have not been given?
Because I don't know.
Yes, what is your stand, Mr. P.N. Sharma? And where's the finance again gone? You have made the finance party.
Finance is party there.
Yes,
Matter has
then
been listed
finance is
in
again
several
gone.
occasions, but it was left over.
Finance is not a party.
Finance is the finance is there, Lordship.
Where is the, oh yes, additional
Yes,
chief
number 5.
secretary finance is there. Yes, why is he not entitled to the minimum of the scale of pay? What is your instruction?
Lordship, my instruction from the director of elementary education department is that there is no any order or direction from the government, because Lordship, the notification.
Yeah, my lord will kindly recollect. He is taking the benefit in pursuant to, my lord, the decision in Upenda 45 of 2014. Lordship has been dealing with these matters for quite some time. After pronouncement of Upenda, post Upenda, an exercise was carried out. Finance department had issued notification because Upendas came on 8/6/2017. Thereafter, in the year 2018 as well as in the year 2019, financial issued notification, thereby calling from all the administrative departments to send the name. It was an exercise, one-time exercise. Because the benefits will have to be given. So now the issue will be whether they have sent the name. Because that was, yes, that was a blanket notification meant for all the departments. Lordship is aware.
So I have to obtain instruction from the government in the school education department, Lordship, whether
Matter of 2022.
2022. 22.
Then
Lordship, that instruction is not there from the government. I have to.
the
obtain-
interesting thing is like this. In the first half, when I take the old matters from 2014, 15, 16, you don't have instructions because those are old matters. In the second half, when I take up new matters, you don't have instructions because these are new matters. So what instructions you will get then?
that instruction from the government, whether their name has been
Huh?
submitted. Because I received the paragraph instruction also from the director of the elementary education.
Why it has not come? Heard Mr. D.A. Kayam, the learned counsel appearing on behalf of the petitioner. I think these matters should go to some court office, some court where it keeps on reminding you. Or it should go as a reminder. Huh. Otherwise, unless a reminder is given in the first half, old matters, second half, new matters, then appears on behalf of the respondent number, on behalf of the petitioner, Mr. P.N. Sharma appears on behalf of the respondent number 1 to 4, and Mr. Arbo Pujari appears for respondent number 5. Mr. Arbo Pujari, the learned counsel appearing on behalf of the finance department submits that that pursuant to the judgment and order dated 8/6/2017 passed in WA number 45/2014. The finance department has directed each and every department to furnish the names who were furnish the names of all casual master roll
Yes, casual master roll workers who are
contractual
no, casual and master roll workers
casual and master who were appointed on in respect to non-sanctioned posts.
and who are entitled to the benefits arising out of Upenda.
Non-sanctioned posts who have rendered service of 10 years with effect from prior to 1/6/2017. Under such circumstances, the learned counsel submits that it is for the elementary education department who needs to furnish instructions in this regard as to whether they had sent the names to the finance department, in as much as those names which have been sent to the finance departments have been cleared. So the learned counsel, Mr. P.N. Sharma, submits that he would like to take instructions in the matter, taking into account the same. Let the matter be listed on 10th of May, 2023, on which date Mr. P.N. Sharma, the learned counsel, shall obtain the necessary instructions.
Okay.
40.
Yes.
We have done our part. The PPO has been issued.
You got it? I have the honor to inform the pension case in has been finalized. PPO has been issued to the treasury. Then what else do you have?
Everything I have received.
I have got good money.
That regular pension has not been deposited to our account.
So should this court wait for that?
No.
Then
By this mentioning this PPO number, you know, otherwise,
heard Mr. H.
Das.
Das, the learned counsel appearing on behalf of the petitioner. Mr. Esa Bulwa appears on behalf of the respondent of the director of pension, and Mr. A. Hassan appears on behalf of the principal accountant general A.E. Assam.
Here, my lord, we have also authorized the GPF amount. The next
You have done, huh? Mr. Esa Bulwa, the learned counsel appearing on behalf of the director of pension, had submitted that the pension case of the petitioner have been already finalized by the Office PPO Authority number ADP/PPO/GPO/2023/K007261 dated 28/3/2023. And the PPO/GPO has already been issued to the Treasury Officer Kualpara. In that regard, the said PPO issued on 28/3/2023 have been placed on record by way of have been already placed on record. Further to that, it has also been mentioned that the petitioner have already received the provisional DCRG of rupees 14,95,000, and the remaining amount of 50,000 be paid to paid. No, 14 lakh, no, 1 lakh. The remaining amount of 50,000 has been directed to be paid, isn't it?
Remaining 5,000.
5,000 only?
Yes, 14
Oh,
lakhs.
yeah. The remaining amount of rupees 5,000 has been directed to be paid, isn't it so?
Lord.
Mr. A. Hassan, the learned counsel appearing on behalf of the petitioners, respondent accountant general had submitted that the GPF amount have already been finalized and settled. And the petitioner would have been held to be entitled to an amount of rupees 21,59,798. And you have directed for payment to the treasury.
My lord,
Huh?
copy to the principal and also to the treasury, my lord. Yes, treasury.
The said aspect of the matter has also been sent to the treasury officer Gwalpara for doing the needful. The communications so placed on record by Mr. S.R. Bolwai kept as Annexure X, and the communication was submitted by Mr. A. Hassan is kept on record as Annex as Y. The communication so given by Mr. S.R. Bolwai is kept on record and marked with the letter X. RA2 A. Hassan kept on record and marked with the letter Y. So taking into account the above, as the grievances of the petitioner have been met, and as such, nothing remains to be decided in the instant proceedings. Consequently, the petition therefore stands closed.
Obliged.
Forty-four.
Yes, what is it?
Last occasion, Lordship has
So many affidavits.
directed me to submit the application, Lordship. Have submitted, Lordship.
Huh?
Last occasion, Lordship has directed me to file an application before Treasury official, Lordship. But I have accordingly submitted, Lordship, on 20.
Perusal of the communication shows that the branch manager has directed the petition to approve the sanctioning for the valid bill. Oh, that one. Which one?
Lordship, this is payment of area pension, my lord, in this matter.
Life certificate.
Yes, my lord. So they have submitted the life certificate, my lord, and Lordship had directed the petitioner to file a representation to the treasury officer. Lordship, upon filing of the treasury, the representation, the treasury officer has written to the state bank authority because they have all the necessary documents. Lordship will go through the letter once, my lord.
What does it say?
Lordship, the treasury officer has asked the bank authorities to calculate the arrear pension remaining, my lords, and the same has been communicated to the bank authorities, but the bank authorities have not reverted it back because once the treasury officer receives those the calculated amount along with other documents, my lords, the treasury officer can forward those documents to the AG, my lord. Lordship, that is a communication dated 3/3/23. They have written to the bank, my lord.
Now you are getting the pension?
I am,
Okay. Well done. Now, what a pursuant to that, now the problem is the State Bank has to be made a party. Oh, yes. You are a State Bank counsel? Very well. There is another matter on 10th. Roha branch. Yes. In that matter, you take the number, you give them the number and ask your chief manager. I've asked the officer in charge of the police station, Roha police station, to serve a copy of the petition. I made the State Bank a party. This is a case of pension where this is happening. All the problem is being done by the pension and all this treasury and all these people, they have done it. Our family pension, which is there, who has not been paid for the last 5-6 years by those authorities. Now the petitioner has been asked by the State Bank, rightly so. Oh, that document is there. Yeah. Rightly so, that you see, if it is more than 3 years, you have to get it proper from revalidated. Now this matter again rolls back. So this is what is happening. Therefore, in that matter, you have the number, you see. I think there's a number, with petition. I think he produced it. You produced the something. It's only I have produced. For that matter, you appear or ask these people, because that day I was looking for the standing counsel of SBI and I couldn't find anybody. That is why I have to send it to the officer in charge of the Roha police. I will. You intimate. And you get a copy. You have the number? You just give it. The copy of the writ petition. Copy of the writ petition I've asked the registry to give. Because this lady has been running pillar to post to get this family pension for 8-9 years. Now what to do? Give us a solution here. Here is a person who has not got it because of the life certificate was not given. Now you are getting your regular pension. Okay, something good about it. Now comes the other one. And what have you done in this matter?
First, the sanction is rehabilitation is passed by the accountant general.
No. In this case,
I'm talking about this.
have you informed the treasury officer as to how much would be the area?
That communication I have not aware about. In fact,
No,
I
this
have
is the
sent my
communication.
opposition yesterday.
This has been written to the chief manager. Who gave me? This?
I have
Yes.
a copy. Dr. I can-
The chief manager, because what is going to happen, how it works out here is this. You have to go and you have to tell them, the chief manager, to the treasury officer. Treasury officer will write to the accountant general. Accountant general will write to the department for area sanction. And then the sanction will be granted, and then comes Mr. Borpujari to give the final authority. Yes, we give the area sanction. And then everything gets regularized, and then he gets the money. This is how it is, a long drawn process for not submitting the life certificate.
Lordship, the PPOs and everything is with the bank only, because of which it cannot be.
So you take it up. You'll have it when? After Bihu. You please inform. Have you informed it to the treasury officer or not? Heard, Mr.
J.
Abbas, the learned counsel appearing on behalf of the petitioner, Mr. R. Popujari appears on behalf of the finance department. Mr. Madam, you are appearing for?
1 and 2.
1. As Puru appears for respond number 1 and 2. You will be writing to the concerned department for the purpose of sanction?
Yes.
The accountant general doesn't come out here now. The treasury officer will write to the
Yes, sir.
to you.
No, treasury officer write to the
No, it will go to the accountant. General,
Accountant
because
general.
once the PPO is issued, PPO is the final document, that is an authority. You pay pension, it is a pension payment order, but that is always issued by my lord, the accountant general. So therefore, it has to be routed for the accountant general.
And who accounts for the accountant general? Madam, you are appearing. Accountant general. Namtuluple appears for the accounting. It has been brought to the attention of this court that the Treasury Officer Lakhimpur, by the communication dated 3/3/2023, had requested the Chief Manager, Branch Manager, State Bank of India, Bihali branch to calculate the arrear pension for the non-payment period as per the records of the State Bank of India, to follow up with the government of Assam to accord sanction for issue of arrear pension authority. The said communication has been placed on record by Mr. R. Bapujari, which is kept on record and marked with the letter X. Mr. Jalan, G. Jalan, appearing on behalf of the respondent number 6, submits that he would take necessary instructions in the matter. This court directs the chief manager, the branch manager, State Bank of India, Bihali branch, Bihali, to forthwith take appropriate steps for sending the calculation to the Treasury Officer Lakhimpur so that the needful can be done. This is the matter on 19th.
19th of April.
You let us know what happens.
45.
Oh, is the matter 2 p.m.? Yes.
The matter pertains to suspend the petitioner was petitioned the suspension lordship on by order dated 26/9/2021. He was arrested in connection to a vigilance.
Yes, why did I fix it today?
Lordship, he is retiring tomorrow. Lordship. Tomorrow he is superintendent.
Okay, what do you want?
Lordship, his suspension orders has been Lordship extended without appreciation of mine. No reasons has been recorded except for pending of trial of proceedings of departmental. On that count, Lordship, everything has been extended.
Where is it?
Lordship, the first suspension is on page 45. 26/9/2021.
He's retiring tomorrow.
Tomorrow, Lordship.
So how does it make any sense? Means why should this court so urgently take it up? Means he wants to retire tomorrow without on being reinstated. Huh?
Lordship, similarly,
By the time this court passes an order, signs an order, in the meantime you are going to retire by tomorrow.
I understand that.
Then
But he was similarly placed Lordship was arrested in connection with the same case, Lordship. And in whose respect also similar extension was also issued. This honorable court was pleased to interpret with those suspension orders, Lordship. And he was reinstated in the same vigilance case, Lordship, released on bail on the same day. Lordship, the suspension order of
who is Dipankar Dihania?
Huh?
And who is he?
Lordship, the petitioner is Dipankar Dihania. Lordship, that the other person here, Lordship, will find the order at page 67, the relevant portion starts, Lordship, in respect of 67, Lordship.
67.
Lordship, that is in respect of Ataur Rahman, Lordship, who was reinstated by this honorable court. Page 67 is correct.
Mr. Counsel, I don't accord the same opinion.
Kindly produce the suspension order.
Let us see that.
That is the first suspension order, it is page 45. sir.
Page 63.
Page 63, Lordship. It is the third suspension order. First was on 26/9/2020.
Now, what is the status of the departmental proceeding?
But no departmental proceedings
What?
have been drawn to that, Lordship.
Mr. Kutuki, there is no department.
No, Milord, the departmental proceeding is not-
How are you suspending him?
because of in custody, Milord. He
Huh?
was detained in the police.
When?
He was arrested on Milord 24/9/21
And released on?
by this honorable court order dated order Milord 18/11/20. That's the page 52. On 18/11/21.
18/11/2021. Why he is still in custody? Why you have not done anything?
Milord, in fact, we wrote to the document based on the entirely seized by the police. Milord. Those were in custody of the police. Unless those who fail to get it, Milord, we cannot issue it now.
Huh?
Because the entire he was placed under suspension on the ground of corruption, Milord, in an interview conducted by him.
Very well, but if you have not taken any action, then how do you take care of Ajay Chaudhary?
Although Chaudhary, Milord, we said regarding he was placed under suspension for pending departmental proceeding. It is under second
No,
part.
Ajay Chaudhary says you have to submit a memorandum of charge within 3 months.
No, Milord, this is the second part, Milord. This is second part means if it is in custody, Milord, beyond 48 hours, he will be deemed to be suspended. And there is a proviso in that provision itself that under we can revoke the suspension on this ground.
Then?
Until and unless those done are not satisfied, Milord, we cannot review the suspension order.
You come under the 64 rule?
No, Milord, it is our 64 rule and perimeter same, Milord.
Ajay Chaudhary has come. Where is that? Where is your rule?
Rule, your lordship, there was earlier order from this honorable court, Milord, that your lordship, the rule was quoted in that order. That your lordship will find at page 173. He opposed this honorable court, the rule was quoted in a page 174.
Page
174.
The officer of the board will change the custody whether criminal charge or unsuch procedure exchange shall be deemed to have conducted with whether that it on bail or otherwise. Then
Therefore, Milord, this honorable court directed us to make an assessment under the provision, Milord. So while granting the bail, Milord, the prima facie this court satisfied that these petitioners are indulging corruption in the interview process. Prima facie, that finding is there.
Where?
In the bail application itself, bail order itself. I court this honorable court. If you lordship have a look on the
what do you say about Satyinder Kumar until about the presumption of innocence?
that's correct, Milord, but here
So should we deal on, should we deal on
Presumption of
that
my lord,
aspect?
here after considering the material and the record cheating, my lord, this honorable could find it. My lord, that finding at page, your lordship have a look on the at page 54, my lord, observation or finding below.
What stops you from carrying out the departmental proceeding? Mr. Kotoki, I'm setting aside the suspension now. Yes, heard me. Your name?
A. Chakrabarti.
A. Chakrabarti. The learned counsel appearing on behalf of the petitioner. Mr. S. Kotoki appears on behalf of
Response number 2, 3, 2, 3, 4, 5.
2, 3, and 4. Who appears for 1? Power? No power. Ms. S. Golwa appears for the respondent number 1. The instant writ petition has been filed by the petitioner. Where is that order of suspension?
Page 45. First order.
Challenging the order dated 26/9/2021, whereby the managing director AEGCL had suspended the petitioner with immediate effect under Rule 31A, Rule 31B, Rule 31C of Rule 10 of the ACB General Service Regulation, bracket for officers, bracket close, 1960, pending drawal of departmental proceedings. It appears on record that the petitioner where did you arrest?
Arrest on, my lord, 24/9/21.
Page 52.
It appears on record that in connection with Vigilance PS case number 4/2021, registered at the section 120B/420/468/471 of the Indian Penal Code 1860, read with section 7C/13 bracket 2 of the Prevention of Corruption Act 1988, the petitioner was arrested on 24/9/2021. Thereupon, the petitioner was produced before the court of the Special Judge Assam on 25/9/2021. The record, as above stated, on 26/9/2021, on the ground that the petitioner was arrested for a period of more than 48 hours, he was put under suspension by the order dated 26/9/2021. It further appears on record that on 18/11/2021, in bail application number 2940/2021, the petitioner was granted bail. The petitioner thereupon submitted a representation dated 24/11/2021 before the respondent number 3, that is the managing director AEGCL, for revoking his suspension and to allow him to resume his duties. It appears on record that instead of that, the respondent authorities, respondent number 2, 3, and 4, have neither issued the memorandum of charges, the charge sheet, have not issued The respondent number 2, 3, and 4, who is the disciplinary authority, have not served the memorandum of charge oblique the charge sheet upon the petitioner till date, but have been continuing with the said suspension order, thereby extending it periodically every 90 days. It is under such circumstances that the petitioner had initially approached this court by filing a writ petition
173.
which was registered and numbered as WPC number 7483/2022. This court, however, had disposed of the said writ petition directing the chairman of the respondent number 2 board, chairman of the Assam Electricity Grid Corporation Limited, to pass a reasoned order upon examination of the claim of the petitioner for vacating the suspension order as inclined above, the as of the suspension order. Then what happened?
But thereafter, the discourse of it in terms of the compliance with statute,
Where is that order?
Page 177. Sir.
It further appears that on 12/12/2022, the respondent, the managing director of the AEGCL Biljuli, AGCL, had instead of considering the case of the petitioner for reinstatement, have further extended the suspension order for another period of 90 days or until further orders. Being aggrieved, the petitioner is therefore before this court. A perusal of the order dated 12/12/2022 shows the provision of Regulation 232 Roman 2 of the ACB bracket General Service Regulation bracket of Officers was 1960. You don't have the regulation. In this fat compilation of your petition, you don't have the regulation. You have or not?
The regulation has not been enacted by the relevant court.
I'm asking you a simple question. Do you have or not?
The entire regulation.
Because you have been suspended under various provisions. Do you have the regulation? No. And you are doing a case. Yes. The fine lawyer with a meek voice. Tell me. Yeah, I can't hear you. Can't help you. This court have perused where's the suspension order?
Page 45.
Page
45.
Have perused Regulation, Rule 10 of the Assam General Service Regulation, bracket for officers, bracket close, 1960. A perusal of the said regular Rule 10 shows that the same is in parameter to Rule 6 of the Assam Service Discipline, bracket Discipline and Appeal Rules 1964. Rule 10.3 Roman 2 is similar to Rule 6.2 of the Rules of 1964. This court had made a had asked the had made a specific query upon Mr. S. Katoki, the learned counsel appearing on behalf of the respondent number 2, 3, and 4, as to whether any memorandum of charge oblique the charge sheet has been served to the petitioner. In the meantime, the learned counsel appearing on behalf of the said respondents with all fairness have submitted that the said memorandum of charge oblique the charge sheet have not been submitted, have not been served upon the petitioner, on the ground that the same could not be prepared in view of
the document pertaining to the offences, are lying with the police.
in view of the fact that the documents pertaining to the dispute pertaining to on the basis of which the authorities would be issuing the memorandum of charge oblique the charge sheet is lying with the police. This court further likes to take note of the judgment of the Supreme Court in the case of Ajoy Chaudhary versus Union of India reported in so and so, wherein in paragraph number 21, the Supreme Court had made categorically mandated that the currency of a suspension order should not exceed more than 3 months unless and until the memorandum of charge oblique the charge sheet is not served upon the delinquent employee. And if served, then there has to be review followed by review followed by reasons to be recorded. The division bench of the Supreme Court of this court in the case of Abatement versus the state of Assam reported in so and so had categorically observed that the principles as laid down in Ajoy Kumar Chaudhary's Supra duly applies to the suspension, duly applies to a case of deemed suspension under Rule 6.2 of the rules of 1964, which is parameter to Rule 10.3 Roman 2 of the Assam State Electricity Board bracket General Service Regulation for Officers 1960. Subsequent thereto, this court had also, by the judgment and order dated so and so in Rafed Ali versus State of Assam, have also categorically held that the law laid down by the Supreme Court in Ajoy Kumar Chaudhary to the effect that to the effect that the period of 3 months in the case of and the period of 3 months as stipulated out there in Ajoy Kumar Chaudhary Supra shall count from the date on which the representation have been submitted. That the petitioner has been released on bail or is not in custody or otherwise not in any custody or detention. It appears on record that the respondent authorities are aware of the fact that the petitioner was released on bail on 18/11/2021. As the same was duly intimated on 24/11/2021. I've also perused the order dated 12/12/2022, by which the petitioner request for being reinstated have been set aside, have been turned down. In doing so, there is no, the authority concerned have not taken into account the judgment of the Supreme Court in the case of Ajoy Kumar Chaudhary. Taking into account that the judgment of the further continuation of the suspension order dated 26/9/2021 by various orders as well as the order dated 12/12/2022. 12/12 are in total are contrary to the law laid down by the Supreme Court. In Ajoy Kumar Chaudhary Supra, this court therefore directs the respondents to forthwith reinstate the petitioner in doing so. Liberty is given to the petition respondent as submitted by the learned counsel appearing on behalf of the petitioner, that the petitioner is going to retire tomorrow. The reinstatement so directed be reinstated.
I'll intimate them. To take a action.
Be reinstated forthwith.
Okay, I'll inform them.
I would they're reinstated forthwith to a non-sensitive post. I put that on forthwith to a non-sensitive post, taking into account the contemplation of the departmental proceedings. It is, however, made clear that before concluding, this court also would like to observe that the petitioner is going to retire tomorrow. And the order directing reinstatement would yes, what should I say? I don't want to say that the reinstatement should continue any further. I only want to say that that is only for one day.
Lord, your lordship passed this order today. Then reinstatement will be there tomorrow.
Not tomorrow, but it has to end tomorrow.
End tomorrow.
Because tomorrow is his last day. Huh?
Yeah. That's right.
I'll just change whatever word is required, I'll put it. Huh? You just intimate. With the above the petitions. Mr. Kotoke, you kindly intimate the authorities about this order.
Yeah.
Today I'll see let him complete it.
No, I'll intimate right
Yes.
But the non-sensitive post may be equivalent to the rank it is.
What?
The non-sensitive post may be equivalent to the rank it is serving.
To
the rank in which you are serving. As the general manager, any equivalent post in a non-sensitive.
Mr. Counsel, I'm only asking for reinstatement, nothing more than that. Don't ask more than that.
46.
Please, your lordship.
Yes.
Matter relates to non-payment of arrear family pension as well as current family pension.
Yes, any instructions, Mr.
Yes, sir.
Yes, lordship, I have filed my affidavit.
What is your stand?
Stand is that,
As to whether the pension proposal of the petitioner has been sent to the Accountant General?
No, lordship will dispose of this matter in terms of Sanjita Rail lot. We have
9
filed
years, 6 years.
6 years.
That is the case.
I can understand that after deduction of 6 years, my service comes out to be 18 years, and that's why my pension is not.
Take it up next week after vacation then. Huh? The matter be listed after on 21st of April.
47.
Not disposed, it will be disposed of on 25th. Same matter.
Huh?
Same matter.
Same.
Same matter.
Same matter covered Sanjita directly.
Covered by Sanjita Roy. Have you got your instructions in this matter?
I was directed, my lord, instructions are, my lord. Same
Anyway,
instruction repeated.
PhD?
Yes, my lord.
I see.
So, my lord, he has a case, my lord. So why don't know
One
why-
department you go and get instruction is PhD.
Well, I don't know what this my officers after, my lord will direct them to forfeit processes pension.
Now we'll have it on 21st.
Well,
Can it be on 26th? Can it be on 26th?
26th. Why?
Right.
Oh, be Eid.
Yes.
Okay, we'll have it on 26th.
49.
My that overdrawal case recovery was done. There is an order dated 15 of this month.
Oh, Rashid Mase. Oh, that one.
Yes,
But I'm looking at the PPO lordship, no overdrawal is shown there, Lord. 46. Case 40.
As per your instruction, he's entitled to return. When I have the honor to inform you the petitioner has deposited an amount due to wrong fixation of her pay as against when petitioner has paid withdrawn but subsequently condoned by the AR as such the petitioner is entitled to the refund. Then nothing remains.
Yes, my lord.
We'll dispose it of on this. Anything, some good thing happens. But Mr. D. Gogoi, the learned counsel appearing on behalf of petitioner, Mr. D. Musari appears on behalf of the respondent number 1, 3, and 5, and Mr. P. Naik appears on behalf of the respondent number 2 and 6, and Mr. S.R. Borua appears for the respondent number 4. The grievance of the petitioner is in the instant writ petition was that the petitioner that an amount of rupees 1,44,133 was forcefully recovered from the petitioner under duress. Accordingly, on the basis of the judgment in the case of State of Punjab and others versus Rafiq Masi, whitewasher, reported in 2015 4 SCC 334, the petitioner had sought for recovery, sought for refund of the said amount. This court, by the order dated 15/3/2023, directed the respondents to apprise this court on the next returnable date as to why the petitioner is not entitled to the refund of the amount of rupees 1,44,133. Today, Ms. D. Musahari, the learned counsel appearing on behalf of the which department? Secondary school education, which department? Secondary education department had submitted that the petitioner that the authorities have already condoned the overdrawn amount of rupees 1,44,133 by the husband of the petitioner. Husband, na? Or by the petitioner? By the petitioner. Accordingly, the petitioner is entitled to the said amount of rupees 1,44,133, which she had deposited. The said communication is kept on record and marked with the letter X. Taking into account the same, the respondent, and more particularly the respondent who is going to pay, return you.
Okay, because proposal has to go from the inspector to direct of secretary. The proposal has to come from inspector.
Under such circumstances, the respondents and more particularly the director of secondary education is directed to refund the amount of rupees 1,44,133 to the petitioner within a period of 3 months from the date a certified copy is served upon the said respondent. With above the petition. Anything more? Mr. Das, you always have an urgency for all matters.
But only date of birth and my lord, name is wrong, my lord. Typographical mistake.
So your name is not here. Matter is there today, no?
43 item.
43?
Mohini Pegu, it is.
Oh no, you didn't mention. The matter didn't come up. It's not there in the list.
Today I am not. Before Bihu, any date.
What?
Before Bihu.
Before Bihu?
21st, my lord, 21st, after Bihu. 21st.
I can do one thing. I can put it at not by me. and then you can try your luck. And I ask the registry to list it before Bihu.
No, no,
Okay.
21st after Bihu.
Then now you come to after Bihu.
21st, my lord, upgrade as I upgraded. Only, my lord, the name is wrong. I'm not getting that pension. Mohini and Manipik, that is
Okay. Item number 43.
21.
Listed on 21st at 2 p.m.